But have you mentioning?
Yes.
Petitioner is the ex-army man. Petitioner is an ex-army man.
Want?
Upgradations, my
No,
lord.
sorry, please don't
Monthly
mention.
list
Your Lordship,
199.
I am not allowing mentioning.
Lordship, I'm seeking leave to file an urgent matter, Your Lordship. So the Your Lordship petitioner is the Your Lordship a branch of Indian Red Cross Society, is a Howrah branch, Your Lordship. So this his allegation is that Your Lordship that the bank account of the district branch, Your Lordship, that are denied to maintain, Your Lordship, by the bank. So that is the Your Lordship the fact.
No, but there was
As a result,
a separate writ petition with the same Red Cross
so
Society.
Lordship, the matter is listed, Your Lordship, as an item number 260
Right.
2665.
And there is an issue with regard to the constitution of the
Formation of
committee,
the board, Your
formation
Lordship.
of the
Formation of
board.
the, yes, Your Lordship. But the Your Lordship, on the last occasion, Your Lordship was pleased to pass a direction, Your Lordship, upon the authority that to disburse
But
the
the-
salary, Your Lordship, to
The
the
district magistrate
employees, Your Lordship.
possibly.
Yes, Your Lordship.
Right.
Yet not been, Your Lordship, disbursed to
That
the, Your
is
Lordship, salary.
different.
Yes, sir, this is the Your Lordship, the matter potential.
No, no.
Since Your Lordship, the salary of the petitioner.
You file it in the department.
My
Fine,
lord, may I have my lord's leave to mention a matter for correction of the order, my lord. I'm
What
mentioning
is the
upon
correction?
notice, my lord.
What is the correction?
My lord, I've indicated in pencil subject to my lord. My lord will kindly recall this is regarding the Jute Packaging Act, my lord, and the compulsory packaging. It has gone down only as food grain industry. Sugar mills, my lord was aware, my lord. It
Is it
should be
separate?
added also sugar mills, my lord. It's 20% sugar and 100% food grains,
All right.
according to the mandatory jute packaging
I'll do
orders.
it. It'll appear in the list as to be mentioned.
My lord, the matter is due to appear on Friday, my lord.
In that case, Friday I can make the necessary correction also. Then there is no requirement of separate listing.
Grateful.
May I have your lordship?
My lord,
Yes.
new motion inclusion
No.
24.
May I have your lordship
Start this matter.
kindly to mention this matter? Your lordship, by your lordship, order on 14 January, your lordship was pleased to mark the matter as motion. However, in the monthly list, your lordship, I have found out that the matter is under the heading of adjourned motion, your lordship. It's item number 117. It should have been under motion because no affidavits have been called for and the matter has not been heard yet. And
No, adjourned motions are all motions only. All motions.
May I have your lordship wish to mention a matter, lordship, for inclusion, lordship?
No, no inclusions.
Your
Lordship,
Lordship, request one thing, Your Lordship, since Your Lordship, the salaries of the employees
No,
yet
sorry,
been
sir.
disbursed,
I cannot.
kindly, Your Lordship.
lordship, may I permit it to mention for upgradation?
No, sorry. Yes, call the list.
Mention one matter, my lord. The urgency is, my lord. Bit urgency is there, my lord.
What do you want? Upgradation?
No, my lord.
Then what?
Appearing in the combined monthly list, my lord.
It is appearing?
No. My lord,
You want inclusion?
Yes, my lord.
Today is not the day. Yes, item 1.
Urgency is there, my lord. Bit-
আমি একদিন এটা কথা বলে নেবো জাস্ট একটু বলে নেবো
Section 14.
Millard, before my learned friend starts, Millard, I was continuing, Millard, on the last day. My lord has passed
Yes.
certain direction. Millard, one judgment I found out, which apparently prima facie stands against my client's contention. That is Seabright. But-
relied on that.
Yes, Seabright. So my duty is to point out because I have found out, even if it stands against my client. Now, Millard, Seabright, it speaks about Millard, the interpretation of Millard, the section 14 of the SARFAESI Act, which says, Millard, that anytime the point of limitation, Millard, it is, Millard, inconsequential, interpreting the statute, Millard, that even if there is a limitation, Millard, prescribed by the statute, since it does not speak about any consequence, it is directory in nature. My understanding of the judgment, because it stands against me and I have to overcome this.
Yes.
So, Millard, it is about 2021. The judgment.
May I place the judgment first because I would have.
I have,
relied on this and then my lordship would have differentiated it.
Who are you?
I am for the state, your lordship, the
District magistrate.
Yes.
It did not take steps within the due time.
and your lordship, because my learned senior friend has raised a point of functus officio.
Yes.
Mandate of 60 days.
Right.
I have a judgment in my favor. So what I was suggesting, subject to what my learned friend said.
Did I say anything contrary to what he would?
No, no.
All right, all right.
Because he's
What was your submission today?
Millard, today, Millard, let him, Millard, say, because I need to distinguish, because these two, petitioner and the state, Millard, they will, Millard,
They lie on the same
same
footing.
judgment. I will also rely on the same judgment, and I will make, Millard, 3 submissions on the point of law for drawing my lord's kind attention on this fact. Let him
Okay.
say, Millard.
yes.
Yes.
dismissal for petition is also on the last population, on the last
can't.
page, also
My private
dismissal
response is
at the
number
point
two.
of termination,
And
This matter.
Yes.
Statement matter, your lordship. So my
Madam Lord, this issue was raised by my learned friend. I have found a judgment of the Honorable Division Bench, and this issue was.
1 minute, and after that I will rely on.
1 minute, where is the bank located?
Yes, your lordship.
That,
So,
that is not a Jivandi building.
and it comes to page 12 of their prayer, your lordship.
Page 12. Yes.
Yes, your lordship, prayer B.
Hmm.
Prayer B is a order a prayer of mandamus. To a writ of mandamus upon disposal number 2. And prayer C is a writ of certiorari.
Hmm.
So your lordship, the papers are lying outside the jurisdiction of this high court.
Where are the papers?
The matter, the property is that the property is that your lordship, the property is of yes. The district magistrate book list. So the papers are lying in district magistrate book list office, which is outside the original jurisdiction of this honorable court. And the mandamus also, your lordship, cannot be applied to the original side of this court. And on that point, your lordship, rely on the original side rules of the High Court rules, whereby Rule 4 and Rule 5. So, your lordship, this is my first point, because these matters cannot be heard in the original side. Because for some reason, they are filing the original side and the matters have been heard. So I have objection under instructions. Upon instructions, your lordship, this is my first
Who has instructed you?
under AOR.
AOR. All right.
Can we take this point? And next, your lordship, on the point of contest officio.
Hmm.
May I place the judgment?
Yes.
হ্যাঁ, original side judicial। না, সেটা তো
Original
Yeah, that has to be
original
decided or-
jurisdiction নেই।
সবাই accept করলে তাহলে
না না consent cannot confer jurisdiction.
exactly.
Yes.
Yes, your lordship. So this judgment, your lordship, first is
কোথায় থাকো
the first paragraph, the challenge in the present appeal. It has page.
Yes.
Yes. The challenge in the present appeal is to an order passed by the division bench of the Madras High Court on 19 July 2019, whereby it was held that section 14 of the SARFAESI Act, mandating the district magistrate to deliver possession of a secured asset within 30 days, extendable to an aggregate of 60 days upon written recording and writing the directory provision. So the question of the order impugned was 30 days, 60 days, whether that is direct or mandatory. This was the impugned order. Now, the question, yes, in paragraph 2, the last line, the High Court observation was for all within the time limit stipulated in the amended section 14 of the Service Act is directory and not mandatory. The High Court opined this. Now, your lordship, para 8. I would rely on certain paragraphs, your lordship, I am not relying.
Which paragraph did you rely right now?
Para 2, your lordship, para 2, last line.
Para 2, last line.
Internal page 8, your lordship.
Yes, yes.
The High Court,
For that reasons. Yes, I get it.
the High Court opinion. From which, yeah, because
Yes, yes.
now, your lordship, I would place para 8.
8. All right.
Sorry, my apologies.
A well-settled rule of interpretation of the statute is that the use of the word shall in a statute does not necessarily mean that in every case it is mandatory that unless the words of the statute are literally followed, the proceeding or the outcome of the proceeding would be invalid. It is not always correct to say that if the word may have been used, the statute is only permissive or directive in the sense that non-compliance with those provisions will not render the proceeding invalid, and that when a statute uses the word shall prima facie, it is mandatory. But the court may ascertain the real intention of the legislature by carefully attending to the whole scope of the statute. The principle of literal construction of the statute alone in all circumstances, without examining the context and scheme of the statute, may not serve the purpose of the statute. Now, your lordship kindly comes to para 13. So, the Honorable Supreme Court, while disposing whether this provision is mandatory or directory, has visited different provisions under different statutes where a time-bound period has been prescribed or subscribed to an officer, be it public or a private. So in para 13, the court distinguished failure of an individual to act in a given time frame and the time frame provided to a public authority for the purposes of determining whether a provision was mandatory or directory, when this court held that it is a well-settled principle that if an act is required to be performed by a private person within a specified time, the same would ordinarily be mandatory. But when a public functionary is required to perform a public function within a time frame, the same will be held to directory unless the consequence therefore are specified. Now your lordship comes to para 21. Ultimately, what was decided in this judgment? Because this judgment, your lordship, is squarely on the point directory or mandatory issue. My humble submission, I will come to those judgments where my learned senior friend Mr. Basu has relied. The question was not this. The question was something else. In para 21, the act was enacted to provide a machinery for empowering banks and financial institutions so that they may have the power to take possession of secured assets to sell them. But also, I just leave 3-4 lines. The true intention of the legislation, the next page.
Yes.
Yes. The true intention of the legislation is a determining factor herein. Keeping the objective of the act in mind, the time limit to take action by the district magistrate has been fixed to impress upon the authority to take possession of the secured assets. However, inability to take possession within time limit does not render the district magistrate functus officio. The secured creditor has no control over the district magistrate who is exercising jurisdiction under section 14 of the act for public good to facilitate recovery of public dues. Therefore, section 14 of the act is not to be interpreted literally without considering the object and purpose of the act. If any other interpretation is placed upon the language of section 14, it would be a contrary to the purpose of the act. The time limit is to instill a confidence in the creditors that the district magistrate will make an attempt to deliver possession, as well as to impose a duty on the district magistrate to make its earnest effort to comply with the mandate of the statute to deliver the possession within 30 days and for reasons to be recorded within 60 days. In this light, the remedy under section 14 is not rendered redundant. If the district magistrate is unable to hand over the possession, the district magistrate will be still enjoined upon the duty to facilitate delivery of the possession at the earliest. Para 23, thus we do not find any errors in the order passed by the High Court. Consequently, the appeal is dismissed. So, in my humble submission, Lordship, this is the only judgment where the time frame was the question of law. The Lordship knows in a judgment there might be a 3-4 questions.
Yes, yes. Then what? Anything else?
Yes, your lordship. Just the judgments referred by my learned senior friend 2023. There were 2 judgments, your lordship. One was Balkrishna Ram Karle 2023 1 SCC 662. Yes, your lordship. This, in my humble submission, kindly see the question of law before the Honorable Supreme Court. The first paragraph. Feeling aggrieved.
Yes.
Feeling aggrieved and dissatisfied with the impugned judgment and order dated passed by the High Court of Judicature of Bombay, by which the division bench of the High Court has allowed the said writ petition preferred by respondent number 1 herein. Secured creditor has set aside the order dated 27th August 2021 passed by the designated authority under section 14 of the SARFAESI Act and directed the designated authority under section 14 of the SARFAESI Act to dispose the application under section 14 of SARFAESI Act afresh. Legal heirs of the original respondent number 2 claiming to be the tenant of the mortgage property has preferred the present special leave petition. Now, your lordship, at para 5, what was the order passed by the designated authorities there? And your lordship, the question of law framed by the Honorable Supreme Court is at para 12. Kindly see that. Therefore, para 12, your lordship. Therefore, the short question in which is posed for consideration of this court is whether, while exercising the powers under section 14 of the SARFAESI Act, the district magistrate or the designated authority to the past could have passed such an order that unless and until the secured creditor terminates the tenancy rights of the third person by following due procedure of law and further orders regarding possession of the mortgage property, then and then only an application under section 14 SARFAESI Act will be decided. So this was a question of law form. Here, the question of law for consideration was never whether the time limit under section 14 was mandated or directed. Now, my learned friend has relied para 24 at page 673, para 24, your lords. Where he has relied as mandated by section 14, your lords. I think
There is no paragraph 24.
sorry, I am relying on an SCC copy.
All right. How does the paragraph start?
Your lordship, the preceding paragraph to para 18.
18.
I'm sorry, this is para 24 of the
All right. Yes.
Okay.
As mandated.
673, your lordship.
Yes.
Topmost,
As mandated.
as mandated by section 14 of the SARFAESI Act, the PM has to act within the stipulated time limit and to pass a suitable order for the purpose of taking possession of secured assets within a period of 30 days from the date of application, which can be extended for such further period but not exceeding every date 60 days. But in my humble submission, this was not the point of consideration. In fact, while this judgment was delivered, 2021 judgment was not even considered. So there are two submissions. One, the question of law has to be seen first before relying on a judgment, which in this case is not the question of law, whether it is mandatory or directed. And second, while this judgment was delivered, 2021 judgment of C bride was not even considered. Now, your lordship, this judgment, the para 18, which I relied right now, is taken from the judgment of another judgment my learned senior friend referred, R.D. Jain. I will just shortly, very precisely show what was the question of law there. Lordship, in R.D. Jain, page 679, para 1. Feeling aggrieved and dissatisfied, this paragraph. Feeling aggrieved and dissatisfied with the impugned judgment dated by which the division bench of High Court, while interpreting section 14 of SARFAESI Act, had held that district magistrate CMM is not persona designata for the purpose of section 14 of the SARFAESI Act. The expression district magistrate and chief metropolitan magistrate as appearing in section 14 of SARFAESI Act shall deem to mean and include additional district magistrate, additional chief metropolitan magistrate for the purpose of section 14, and the borrower has preferred the present appeal. So this was the question. This was the impugned order. Persona designata, who are empowered under section 14. So, the Lord, this discussion starts from para 80, whereby the Honorable Court got a chance to visit the scheme how and why this act is there and why this legislation was drafted. If you look at para 18, it starts with statements of objects and reasons of the SARFAESI Act. And it goes on, your lordship. Here, paragraph 24 was relied by my learned senior friend, which is again quoted in another judgment, which I have shown right now. So, my humble submission is, in these two judgments relied upon by my senior learned friend, the question of direct mandatory was not there.
All right.
It was on different issues.
Very well.
The direct mandatory issue was only.
Now he lives in distinguished.
Now, Milord, kindly lend your lordship's ears, Milord, because possibly
To the
he will be
petitioner
listen
also.
with this.
So I adapt his submissions, Milord. I would have cited the same judgment plot. See, Bright, I'm carrying the judgment plot. He is already elaborated.
So, Milord,
on
I need to address your lordship, Milord. Kindly give me, Milord, 15 minutes time. Section, Milord, 14. Section 14. Milord, the first chief metropolitan magistrate or district magistrate to assist secured creditor in taking possession of secured assets. I am skipping over, Milord. Next page, Milord. Proviso clause, Milord, kindly comes, Milord, to proviso clause. My lord has got it.
Yes.
Provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purposes of taking possession of the secured assets within a period of 30 days from the date of application. Provided also that if no order is passed by the CMM or district magistrate within the said period of 30 days for reasons beyond his control, he may, after recording reasons, in writing for the same, pass the order within such further period, but not exceeding in aggregating 60 days. Provided also not exceeding in aggregate 60 days. Kindly take note of this. Now, my lord, that's all. Now, my lord, my learned esteemed friend, my lord, while my lord sought to distinguish, my lord, the judgment of my lord 2023 of this, my lord, no, 2023 of the 662, no, not Seabright, my lord, yes, Seabright, RD Jain, my lord, I passed, my lord, 2023, just a minute. Ek minute. Yeah. Yes, Millard, only Millard first he sought to distinguish, Millard, the Bal Krishna, Millard, grammar Tarle. Kindly sees, Millard, he has read, Millard, paragraph 12. Therefore, the short question which is posed for consideration of the court is whether, while exercising the powers under section 14 of the SARFAESI Act, DM designated authority could have passed such an order unless and until the secured creditor terminates the tenancy rights of the third person by following the due process of law, and further orders regarding the possession of the mortgage property, then and then only an application under such and such shall be decided. He read for my lord's consideration only paragraph 12. Now kindly comes to paragraph 13. While considering the aforesaid question / issue, the scope, ambit and jurisdiction of the DM / designation authority under section 14 of the SARFAESI Act are required to be considered. This was not read. So it is not that the issue was not before the Supreme Court and issue is not Adjournment. So now the Supreme Court, while interpreting this, my lord, the Supreme Court, my lord, has come to a definite, my lord, conclusion. Proceeding, my lord, kindly see. The RD Jain was quoted, my lord, with approval here, my lord. That is why I need not take my lord's, my lord, waste my lord's valuable public time. Kindly turns then, my lord, RD Jain and capital, that is 2023, 1 SCC 675. My lord, kindly, my lord, turns, my lord, paragraph 24. As mandated by section 14 of the SARFAESI Act, the CMM DMM has to act within the stipulated time.
Yes. Yes.
Oh, sorry. Has to act within the stipulated time and pass a suitable order for the purposes of taking possession of the secured assets within a period of 30 days from the date of application, which can be extended for such other period not exceeding the aggregate 60 days. Thus, the power exercised by such and such is a ministerial act. He cannot brook delay. Time is of the essence. This is the spirit of the special enactment. Now, my lord, can we say today at the, my lord, another paragraph, sorry, my lord, 26টা দিন না 32 sorry আগের দিন পড়িয়েছি। It cannot be disputed 32 that the litigation under SARFAESI Act and proceeding or application under section 14 of the SARFAESI Act are increasing, even as noticed by the High Court in the impugned judgment and order dated such and such. 926 cases were pending under section 14 of the SARFAESI Act before only 1 CMM. Therefore, a number of applications under section 14 are pending. It also cannot be disputed that the SARFAESI Act provides for expeditious disposal of the application filed under section 14 of the SARFAESI Act. As per second proviso to section 14, suitable orders for the purpose of taking possession of the secured assets are required to be passed within a maximum period of 60 days from the date of the application. So, my lord, Supreme Court was quite conscious of, my lord, the existence and interpretation as well as the intention of the Parliament, my lord, while, my lord, dealing with the issues, my lord, informed, my lord, public law domain. So it is not that the Supreme Court has given go by, my lord, to the interpretation of the statute as well as the object and reasons of such enactment. Now, my lord, I will rely on a judgment. Now, my learned esteemed friend's contention that for the enactment, the purpose, my lord, has to be considered. Now, my lord, your lordship knows, at the cost of trying reputation, my lord, I take my lord's kind attention to the fact, my lord, when the section is clear, the court did not, my lord, travel into the object and reasons. So, my lord, the High Court of your lordship's High Court, my lord, division bench presided over by Justice Boshak, my lord, of late has said, my lord, relied on, my lord, a judgment reported in, my lord, 2025 SCC online, Calcutta 816, my lord. My lord, why I have placed this, my lord. This paragraph 12, my lord, says even an evil consequences, my lord, flow from the statute. May I repeat? Even if evil consequences flow, my lord, even then, my lord, a statutory authority, my lord, can take recourse to other interpretation, because, my lord, we and the bank, my lord, both under, my lord, working under a constitution, not over it. Even the Supreme Court, my lord, is working under a constitution, not over it. So, my lord, today, if my learned friend's contention being a state authority, that he, my lord, can stretch by reason of his own imagination, my lord, to extend, my lord, the scope and ambit of the act. And because if he does not do so, my lord, then, my lord, the evil consequences will follow. This High Court said, relied on, my lord, the Supreme Court, that even if the evil consequences, so long it is alive, it has to be. So, my lord, going to the object and reasons of such enactment is redundant at the end of the day when the section itself is clear. I will show, my lord, another two judgments which says, my lord, when statute prescribes a time limit, when statutes, my lord, delineates or elucidates, my lord, a particular mode of acting, my lord, then such authority must, my lord, travel within the scope and dictum of the statute, not otherwise. My lord, Nazir Ahmed, I will not burden your lordships, my lord. Otherwise, my lord, we will be lost, my lord, in the jungle of, my lord, the precedents. Next, my lord, I will take your lordships, my lord, only one judgment, 2013, 2 CHN, page, my lord, 171, paragraph 12. Why I tell your lordship? The applicant is the State Bank of India, is a creature of statute, namely, my lord, it's a juristic person. Now, my lord, your lordship knows, my lord, from time immemorial, it is the consistent view of the High Court and Supreme Court, the juristic person. What is the role, my lord, to be played by the juristic person? Para 12. My lord, yes. My lord, why I am telling this, my lord? Paragraph 12, 2013, Division Bench, my lord, 2 CHN, page 171, paragraph 12 at page 175. May I read for my lord and then I will hand over. বইটা দিয়ে দিন তো জজ সাহেবকে।
No, it's all right, you read.
আমি দিচ্ছি কোথায়? It is a settled legal position of law that statutory body must act within the framework of the statute and cannot travel beyond the statute. One individual can do all things save and except those which are prohibited under the law, whereas the statutory body only can do anything as are prescribed within the jurisdictional parameters or control of the concerned statute. Reliance is placed on judgment, my lord, 40 CW when it started its journey, my lord, and it ended with, my lord, 2008, 9 SCC, page 177. Consistent view, my lord, relentlessly consistent, my lord, the Supreme Court has said it is a statutory body. The day on which the application was taken up for consideration, that is much beyond the time limit prescribed by the statute. If statute, my lord, creates a prohibition by express language, my lord, it's the conscious choice of the parliament, my lord. My lord, it is not for the court to decide that whether, my lord, parliament was unmindful of its time. Parliament was very much, that is why your lordship says many a times, presumption of constitutionality is inherent. So, my lord, today, my lord, my learned esteemed friend, or my lord, from the bank or as well as from the state, cannot say, my lord, that they have a liberty or, my lord, the freedom to, my lord, take its own recourse in order to, my lord, give, my lord, effect to the object and reasons of the act. Such pseudo exuberance in the name of, my lord, the public interest, my lord, is a misnomer and, my lord, anathema to the rule of law. So, my lord, I request your lordship, my lord, that functus officio and see bright, distinguishable factors see bright, my lord. Such exuberance, my lord, I tell your lordship, my lord, with humility, kindly turns, my lord, paragraph 21. I read, my lord, at the cost of tiring repetition because this was possibly, my lord, not emphasized. Therefore, section 14 of the act is not to be interpreted literally without considering the object and purpose of the act. If any other interpretation is placed upon the language of the act, it would be contrary to the purpose of the act. Till that, my lord, this is very impressive. The time limit is to instill a confidence in the creditor that the district magistrate will make an attempt to deliver possession as well as to impose a duty on the district magistrate. I put emphasis on the deliver of possession, not the date of passing of an order. So Supreme Court was consciously silent, my lord, hit by doctrine of silence, my lord, so that the Supreme Court is only concerned with, and my lord, I read further, my lord, it would be, if any, the time limit is to instill a confidence in creditor that the district magistrate will make an attempt to deliver possession as well as to impose a duty on the DM to make an effort, honest effort, to comply with the mandate of the statute to deliver possession within 30 days, not, my lord, the passing of the order. You did not make any attempt, And my lord, there is no explanation as on date from the file government records that why such delay caused and whether it was beyond his reasonable control. If in absence of such, my lord, delivery of possession is one part of the story, another part of the story, my lord, to pass an order after taking consideration. My lord, I'm sorry if I have my lord, raised my voice, my lord.
It's
My
all
lord,
right.
my lord, only, my lord, the judgment which I have relied on, I will make a photostat copy.
No. Give me the name of the parties, please.
2013.
No, 2013 I have taken down. Give me the name of the parties.
একটু দাঁড়া বাবা। প্রফুল্ল কুমার ঘোষ versus State of
All
West
right.
Bengal. Paragraph 12.
Yes. It's all right.
So, my lord, see bright, the paragraph 21 is a distinguishable feature is this, and my lord, and RD Jain, and this was presumption is, my lord, this is the latest judgment, and which takes note of these two judgments, my lord, with approval, my lord. And it is true, which it says, my lord, 2021 too, but Seabright has to be adjudged on the anvil of the two part. Section 14, taking up for consideration and delivering possession. I am not on delivering possession. কোনো point বাদ দাও। Yes, my lord. Only one judgment of the Delhi High Court in order to lend meaningful assistance subject to correction. The illustrative, because Delhi High Court Division Bench has, my lord, given one interpretation regarding the filing of a written statement in the context of this SARFAESI Act and rules, DRT rules. It says 30 days and 15 days extra. If we do not file a written statement within the time, there is also, my lord, no consequences there, but the Delhi High Court says it is mandatory.
No, but then written statement were to be filed by the
No,
parties is
my lord,
different.
in a commercial
And this
code,
is,
after the promulgation of the Commercial Courts Act, that is also mandatory 120 days.
yes.
But in a normal litigation between the two private clients, my lord, that is not mandatory. But in this case, my lord, statutory obligation also, they said, no, do not do this. So, my lord, today, my lord, the language is the same, not exceeding. The language is same. Why I am requesting? I request my lord, to take note of this judgment. 2021 SCC Online, Delhi, my lord, 4311, Division Bench, presided over by Justice Vipin Sanghvi. So, my lord, I am only pressing, my lord, paragraph 29. It is just but I only said the two in the two provisions of the same statute, it is same language. And my lord, 29, my lord, Rule 12, if the defendant fails to file the written statement of his defense, including claim for setup or counterclaim under the sub-rule such and such within the period of 30 days, the presiding officer may, in exceptional cases and special circumstances, to be recorded in writing, extend the period by such period not exceeding 15 days. So, my lord, this not exceeding 15 days, same section 14. The Delhi High Court said it is. So, my lord, I tell, my lord, at the cost of tiring repetition, Supreme Court, Seabright was only concerned with the delivery of possession. That means presupposes existence of the order, my lord, passed by the DM within time. Had it been a case, the Supreme Court was very much vocal because Supreme Court was consciously silent, my lord, while dealing with the issue. That is, my lord, my respectful submission. I mean, and jurisdiction, my lord, no. And jurisdiction, I am not taking this point. I am only taking this point of a functus officio because statute does not give him the power.
All
So,
right.
if it is a and statement.
What will be your submission with regard to the jurisdiction point?
Jurisdiction, my lord, I am not carrying a judgment of this honorable court, my lord.
For the sake of convenience, the two sides have been,
No, my lord. I am
Yes.
hit by, my lord, my learned friend has pointed out, my lord, I am hit by Rule 4 of the original side rules. my lord.
yes.
Rule 4 and 5. My lord, this judgment, may I place the judgment, my lord? Yes, yes. Well, this judgment, my lord, the only point involved, when I am placing the judgment, the only point involved in the instant writ petition is whether Rule 4 of the writ rules is mandatory in nature and invites an order of dismissal if the same is not adhered to. It is no doubt true that the High Court frames rules relating to an application under Article 226 of the Constitution of India, incorporating various provisions relating to procedures to be adopted in this regard. By the impugned order, the single bench has held that said Rule 4 of the writ rules is mandatory in nature, and the moment the court finds that the same to be mandatory, an infraction of the aforesaid provision invites immediate dismissal of the writ petition. Lord, I am not reading the entire judgment, but I am not, your lordship, I am inviting your lordship to come to my lord, paragraph 12, page 2. The Calcutta High Court is one high court only for the purpose of administrative facility. There are two sides, namely original side and the appellate side. It cannot be said that the Calcutta High Court has been divided into two high courts, namely Calcutta High Court original side and the Calcutta High Court appellate side. A judge of the Calcutta High Court is a judge of the Calcutta High Court as a whole, and it cannot be said that the judge sitting in the original side is judge of the original side of the Calcutta High Court, and the judge
Yes,
sitting
the
in
court
appellate
went
side.
on to convert
yes,
it to
yes.
the appellate side.
Yes, but it says, but the last, the court has ample discretion on the past, but I am placing paragraph 13. It is well settled that long-standing practice of the court should not be normally disturbed. Since this will create administrative problem of this court. It is manifestly seen for the aforesaid observation that in the absence of consequences having been provided for non-adherence to the provision contained in rule 4 of the writ rule, the said provision cannot be regarded as
Very well,
mandatory.
very well.
This judgment in fact helps me.
Yes.
Into paragraph 6.
Don't press this. I'll take into note.
Because I am not for dismissal.
Yes, I have followed that.
And your lordship would be kind enough to give me a chance to dismiss the judgment with a Basu. I can do it tomorrow itself. I
No.
have the sign on
How
it.
many times? You are for the respondent.
Because
He
we have
has,
that on certain judgments today for the first time.
yes.
I would have the citance of that, or else I would not have troubled your lordship.
I don't think there is any requirement. Please.
But see bright, I have one submission, but your lordship, while taking note, but my learned friend has elaborately assisted you. Paragraph 3, but that lays the foundation of the judgment. What is the ultimate purpose of the act, and that is a recovery. But it is an undeniable fact, they owe 46 crore to the bank. And there is no attempt on their part.
Court
to
is
pay
not
back.
disturbed by the amount. Court is disturbed by the procedural and the law.
Yes.
So that lays the foundation. That creates the foundation for this judgment.
That does not give him a license, Miller, to do anything, whatever.
I
it
have
is.
done anything wrong, Lord. I have approached the district magistrate on time. It is a district
Yes,
magistrate
very
who
well.
could not.
Have you given any reason as to why the
No,
district
no,
magistrate
no.
could not?
No, that is for him to give reasons.
Yes, but then you also do not know any reason.
No,
No.
The DM has also not given
No,
any reason as to
no.
why it sat over the matter for so long.
yes,
No reason given.
no.
I can make the fact better, but it is that.
Obviously, you cannot make something which is not there. Very well. Heard submission made on behalf of both the parties.
Deeply obliged.
Judgment is reserved.
2 and 3 also similar matters.
Lord,
Similar parties are.
I am appearing on behalf of the respondent number 2 in the matter of 2 and 3. But if your lordship kindly sees, the application was made on 1st June 2023. Section 14 says, my lord, if my lord, within the period of 60
Same
days,
bank. Same bank.
Same
no,
bank.
same bank is the same.
You have to hear this matter. Would your lordship be kind enough to?
Is it anything different?
No, your lordship. In the first matter, Mr. Basu has argued on the first day. So I took the point that since Mr. Basu has argued, the point.
So
of
same argument will be here.
Will be here in respect of item number 2 and 3. All the private respondents, I am appearing.
Yes.
But my lord, here the case is, my lord, on 1st June 2023, the application was made. If your lordship kindly sees the prayer. 1st June 2023, now we are in the month of February of 2025.
That is precisely
Absolute inaction on the part of the DM.
That is up to the DM.
precisely the issue dealt with in Seabright.
Yes.
But I
Because there is no bar to create a fresh application. Section 14 gives the provision. Power to the applicant
Affidavit of
bank.
service is taken on record. Heard submission made on behalf of all the parties. Judgment is reserved.
Great.
Next one is also same.
Same analytic.
Put in your appearances.
Yes.
I'm grateful.
My application, your ladyship. Under challenge before your ladyship today is the state is here. Due to service, they are here.
Can the writ petition be taken up in the original side? Why have you filed it in the original side?
So all the respondents are from the original side.
I see all Bidhan Nagor.
No, tender
Next
inviting.
Public health is Ganesh Chandra Avenue.
No, তুমি কোথায়?
Tender inviting authorities, my lord, directorate. That is 3 and 4.
Yes.
They are the respondents.
Ganesh Chandra Avenue.
Not sure. এই রিপোর্টটা কোথায় দিয়েছো?
Yes. Ganesh Chandra Avenue, both of them.
No, Alipur division PH. Where is the office?
Respondent number 3 and 4, yes.
They are the main authorities
yes.
answering respondents. All right, what is the issue?
But they are the tender inviting authorities, 3
Yes,
and
3 and 4. The issue before your ladyship today is the notice inviting tender which has been floated on 8th of January 2025. Now, I say, your ladyship, I'm being led by Mr. Bhattacharya since he has arrived.
The only short point for consideration here is, apart from the facts, the only short point is whether the selection can be restricted only to the existing persons who have, here your lordship will be pleased to find, from documents that, this same authority, in Ganesh Chandra Avenue has awarded me work orders in respect of other works, which are ancillary, not exactly the same. Ancillary work, construction work, repairing work, these sort of works have been assigned. Here it is maintenance and upkeep of bungalows, government bungalows, indicated. From the tender document, your lordship will be pleased to find, serial number 1 and serial number 4, there is an apparent, inconsistency. Be that as it may, I take it, that they have consciously done it from the tender document. Now, they have earmarked the eligibility criteria to include that only persons having a similar nature of work experience, same nature of work experience will be permitted to apply. My only humble submission is, if your lordship now takes, as a similar work order, by the same authority is page 31.
Show me the eligibility criteria.
The eligibility criteria
Page 45.
is page 45.
Yes.
It begins at page 44. First, I show your lordship, the tender. It might not take the trouble to come to page 44 first.
Yes.
Before I show you lordship 45. Please see serial number 1 and 2. Serial number 1 and 4. The nature of work.
Yes.
Day-to-day operation and maintenance regarding sweeping, cleaning, etc. Washing of linens, plumbing and sanitary works of Urmi Mukhar, Urmi Mala, Torongo and generator building at Ganga Sagar. And please see 4. Day-to-day operational maintenance of Urmi Mukhar and Urmi Mala Banglo. I do not understand why have they been separated. Be that as it may, the working experience is page 45. Intending tenderers should produce credentials of operation and maintenance work of a government bungalow of the minimum value of 40% of the estimated amount. Now, admittedly, insofar as I am concerned, I am a tenderer awarded by the same authority, Alipur division in Ganesh Chandra Avenue, page 31. Please see. This is also government work providing FHTC, including parallel distribution pipeline at zone of Mathurapur for mega
This is
surface.
no
water.
way related with maintenance.
Now, the issue is bungalow maintenance. I have constructed schools. I have constructed bungalows. I have constructed barracks for the government. Now, this construction part would also necessarily entail maintenance part. It necessarily means, maintenance is an answer. First is the construction part.
Why do you want to poke your nose in every tender?
What I want to do is, I am indicating to your lordship. I am only inviting my lord's kind attention so that the scope of work is not restricted amongst the favored coterie of whoever is participating. Only 4 tenderers, I am told, have the desired eligibility. Only 4 in the entire state, or perhaps this is the entire state. Now, only 4 persons, if it is restricted, your lordship's court as well as the Honorable Supreme Court in innumerable places have laid down that Article 19(1)(g) cannot be restricted. It has to, if I do not get a chance, the question is, I might fail in rates, I might fail in a number of other things. But the question if it is only restricted to only persons who are adept in, my lord, washing linen, my lord, I can also do the same thing in a different way.
You do it somewhere else. Why you want to go over there? This is a
No, not
government
that.
concern.
This is just an endeavor, my lord, to participate in processes where it is where the processes ought not to be restricted. Now, my lord, if your lordship sees my representation,
Listen, there is an eligibility criteria.
yes,
Either you
my lord, the
meet it
Supreme Court
or
says,
you don't.
the Supreme Court says your lordship is exactly, my lord,
Yes.
there cannot be two views, that the language of the tenderer is depending on the tender inviting authority. I have got that judgment also. It entirely depends on their vision. But the question is whether the process can be restricted in this roundabout way. My lord, whether it is a tailor-made condition, my lord, kindly
I don't
see,
find this
kindly see
prima facie
2009
does
6
not
SCC.
appear to be tailor-made.
Kindly see 2009 6 SCC. My lord.
One who can build can also maintain.
My lord, one who can build can also maintain.
One.
One who builds
Yes.
can also maintain.
No, you are a specialist in building,
Not only, my lord,
constructing
my lord,
buildings,
upkeep,
bungalows.
maintenance and operation
I understand.
is ancillary, my lord. It's an incidental thing to the building.
Being constructed.
My lord, please see, my lord, these paragraphs. Just, my lord, before, my lord, your lordship, my lord, calls it a day, my lord.
26.
Please see 26. This is 2009 6 SCC 171 Meerut Development Authority. Now, please see 26.
Yes.
A tender is an offer. It is something which invites and is communicated to notify acceptance. Broadly stated, it must be unconditional, must be in the proper form. The person by whom the tender is made must be able to and willing to perform his obligations. The terms of invitation to tender cannot be open to judicial scrutiny. I'm sorry.
Yes.
What have you done? Please take.
Doesn't matter. I can handle it. I can handle it.
No.
Don't get
Kindly give
excited.
me back.
It's all right. Yes.
The terms of the invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm of a contract. However, a limited judicial review may be available in cases where it is established that the terms of invitation to tender were so tailor-made to suit the convenience of any particular person with a view to eliminate all others. This is one. Then the other judgment, 2008. 7-8 SCC page 1.
36.
Please see paragraph 36. Please see paragraph 36 at page 21. We find merit in this civil appeal.
Yes.
I'm sorry.
No, it's all right. Carry on. Yes.
Standards applied by courts in judicial review must be justified by constitutional principles which govern the proper exercise of public power in a democracy. Article 14 of the Constitution embodies the principle of non-discrimination. However, it is not a freestanding provision. It has to be read in conjunction with rights conferred under article or by other conferred by other articles like Article 21. The said Article 21 refers to right to life. It includes opportunity. In our view, as held in the latest judgment of the Supreme Court in Saransat, Article 21 and 14 are the heart of the chapter on fundamental rights. They cover various aspects of life. Level playing field is an important concept while construing Article 19(1)(g) of the Constitution. It is this doctrine which is invoked in the present case. When Article 19(1)(g) confers fundamental right to carry on business to a company, it is entitled to invoke the said doctrine of level playing field. We may clarify that this doctrine is, however, subject to public interest. In the world of globalization, competition is an important factor to be kept in mind. The doctrine of level playing field is an important doctrine which is embodied in Article 19(1)(g) of the Constitution. This is because the said doctrine provides space within which equally placed competitors are allowed to bid so as to subserve the larger public interest. Globalization, in essence, is as to subserve. So I am on placetum D. This level playing field is apparently denied to me. I am not saying
there
one
are
rider.
others.
I know. I am trying, to just, express my mind, by saying that apparently on a plain reading of the provision, I don't. But, kindly visualize that a person who is also awarded contracts for a different work can also may not be permitted to apply if may not this operation and maintenance is widened so as to include may not construction, because construction includes may not installation of taps, construction includes may not installation of everything may not.
Very well, I've got it. Yes.
My lord, my first respectful submission regard
How many bidders are there?
already, lordship, four were there and it has been. Lordship, my first full submission is with regard to fact. My lord, if I may respectfully invite your lordship, my lord, to the neat, my lord, at page 44, which is under challenge.
Yes.
Time schedule, my lord, may I respectfully invite your lordship to page 45. My lord, kindly see the time schedule, my lord, clause 6 of the neat. My lord, date for opening of technical bid was 27 January, may at page 46, 27 January 2025. Lordship. Now, if may tribunal lordship with paragraph 8 of the writ, my lord. Para 8 says, my lord, page 7 of the pleading, my lord. Para 8, page 7. As per the tender dated 8th January 2025, the bid submission period commenced on 9 January 2025 at 11 a.m. and concluded on 24 January 2025. According to the prescribed schedule, the opening of technical proposal was scheduled for 27 January 2025. However, despite that lapse of stipulated time frame, technical proposal have not been opened yet. Wrong submission. On fact, my lord, may I hand over respectfully, my lord, the report, my lord. It says, my lord, that it has been opened as usual on 27 January. Technical bid was opened. Accordingly, after technical, the financial bid was opened on 6th. Lordship kindly sees the penultimate paragraph of the first page of the report. After financial proposal opened on 6th February 2025, now at present the work order is prepared to be issued today. So in the offing, work order. So this is on the factual aspect of the matter. Second, my lord, point of law.
After notice of the writ petition.
My God, 6th February 2025. It was opened, lordship. Second, my lord, on point of law, Locus. This gentleman never participated in the tender. So, my settled proposition supported by judgment that a fence sitter cannot challenge the tender. My lord, may I respectfully hand over the judgment? Lordship.
Had I participated, challenge. Then may not participate in challenging.
Lordship, reported judgment based on Supreme Court judgments. Based on Supreme Court judgments. Lordship, my lord, may I respectfully just tell tribunal lordship with few paragraphs of this judgment? My lord, lordship, kindly have a look at paragraph 12. So here also para 1 kindly sees. Qualified to participate in an interview, he alleges, but did not. Now straight away, paragraph 12. I realized in this matter, I appeared for the state. Learned counsel for the state cites NG project for the process that mere disagreement with the decision-making process or decision of admin authority is no reason for a constitutional court to interfere. Any contract of public service should not be interfered with lightly as per the said judgment. In any case, there should not be any interim order derailing the entire process of the services meant for larger public good. Multiple layers of no lordship. Kindly have a look at me, lord. Paragraph 13, lordship. I should travel your lordship. Learned counsel next cites Airport Authority of India reported that so and so for the proposition that if the petitioner could not have participated in the tender process, the High Court ought to have dismissed the petition on the ground of locus standi. Moreover, the terms and conditions of invitation to tender are within the domain of the tenderer and not open to judicial review, scrutiny, unless arbitrary, discriminatory, malafide. And my lord, next, my lord, paragraphs 15 to 17. Paragraphs 15 to 17. Lastly, citing Joshua Motibai Desai, reported at so and so, it is argued that unless the appellant is denied or deprived of legal right and has sustained an injury to any legally protected interest, the jurisdiction in Article 226 would not be exercised in his favor. 16. An important feature in the present case, which emanates after hearing counsel, is that the petitioner, despite having pleaded to be eligible, did not participate in the tender. Nothing prevented the petitioner from participating in the tender process. And having attended the previous meeting, raising the questions as raised hearing. The same was, however, Bulchi, previous meeting was not there very much. The same was, however, not done by the petitioner at the relevant juncture. Even the subsequent representation of the petitioner contains two issues, one of which. Thus, going by the ratio laid down by the Supreme Court in the judgment cited the petition in
Joshibhai and Airport Authority, the petitioner cannot be said to a locus standi prefer, which fence sitter cannot be allowed. Lordship, now, my lord, the second judgment which I'd like to rely upon is, my lord, that the clauses of tender depends upon the wisdom of the author of the tenderer. My lord, scope of judicial review, my lord, is very important, my lord. 2022 SEC online, that is the Airport Authority judgment. Lordship, on the proposition, Locus, here my learned friend has taken another point in the writ petition, the segregation of the similar type of job, serial 1 and serial 4 of the tender are identical by nature, hence segregation only with the motive to inflate the tender estimate. This is one of the grounds of challenge in the writ petition. My lord, the same thing has been dealt with by the Honorable Supreme Court in this particular matter. And tailor-made clauses to suit some people. My lord, may I respectfully invite your lordship to this particular report of the Supreme Court. My lord, 2022 SEC online SC 1334. My lord, I may travel your lordship, my lord. Paragraph 1 kindly sees the fact. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 14 July 2021 passed by the High Court at Delhi at New Delhi in the petition number so-and-so, by which the High Court, in exercise of its power under Article 227 of the Constitution of India, has allowed the said writ petition and has struck down the decision to carry out region-wise sub-categorization of the 49 airports falling under Group D1. The stipulation that any previous work experience in respect of previous GHS is ground handling service, the full form, to scheduled aircraft shall be considered acceptable for the purpose of the impugned tender, RPF. RPF is request for proposal. And the revised minimum annual turnover criteria of INR so-and-so are discriminated so-and-so. Now a challenge. What was the challenge, Miller? Kindly see paragraph 3, the challenge. Respondent 1 herein Center for Aviation Policy, Safety and Research filed a writ petition before the High Court challenging the eligibility criteria and the respective RAPs with respect to group
But
CD.
prior to going further,
So
Mr.
tailor-made.
Bhattacharya, one minute. Since the work order has already been issued, what is the use of going into all these things?
And he's a
now?
non-participant. No locus.
Yes, that I have followed. Now, it's only for academic discussion that this proceeding is going on.
Till yesterday night, the instruction was from the end of my clients, at least, that nothing has opened.
No, he may not be knowing the right thing. The submission of the state is that it has.
Nothing is there in the website, I am told.
Website.
Maybe they'll update it, but it's on 6th of February 2025. It has been opened, and you have filed it on the 10th of February. So it's after that. The cause of action has already gone. No use going into all these things, keeping all these things. These are all settled things. But then if you have to look into it, it's no use. It's only academic. Please come.
No, only one indulgence. Key. Mr. Post request me and Mr. Pal takes it up tomorrow. We shall come with.
Why?
Not just for the purpose, whether
Allow me to.
Why will I disbelieve, and why will you also disbelieve the?
Not Mr. Galib. Why?
No, not Mr. Galib. The instructing person. He is only speaking out whatever is there in the instruction.
Sure.
He doesn't have any role. It's only person of instructions.
May I take a look?
Yes.
Creature of instruction, Lordship.
Obviously. The petitioner challenges certain terms and conditions of the
as usual, technical
notice inviting e-tender
thereafter 623 financial
number. It a copy korben to. Dated 8th January 2025. Floated by the Office of the Executive Engineer, Alipur Division, Directorate of Public Health Engineering. Stuff. According to the petitioner, the eligibility criteria and the working experience has been set out in the notice inviting e-tender in such a manner that it is tailor-made for a handful of bidders. Step. According to the petitioner, the terms and conditions should be such that there is maximum participation and not only restricted to a handful of persons. Stop. Paragraph. Several precedents have been relied upon by the petitioner in support of the above submission. Stop. Learned counsel representing the state respondents draws attention of the court to the date and the time schedule mentioned in the notice inviting e-tender. Stop. It appears that the tender was uploaded on 8th January 2025 and the date of opening of the technical proposal was 27th of January 2025. The date of opening the financial online bid was to be intimated later. Stop. It has been, a report has been filed before this court, signed by the executive engineer, Alipur division on 12th February 2025, mentioning that the technical proposal opening date was 27th January 2025 and it was opened on the same date, the financial proposal was opened on 6th February 2025. Stop. The work order has been prepared and is to be issued today. Stop. Paragraph. It appears that the petitioner has not participated in the tender process as he was not eligible to do so in view of the eligibility, do so as he did not meet the eligibility criteria mentioned in the notice inviting e-tender. Stop. At this stage, after the tender process is practically over, there is absolutely no reason to proceed with the hearing of the instant writ petition. Stop. The respondents may proceed with the issuance of the work order in accordance with the tender document. The writ petition stands dismissed. You can take back all the judgments, no use keeping.
Yes.
State also, it respondent derke ferat diye din. Report is retained with the records. E duto petitioner kaছে ferat jabe.
Thank you. Gratefully, Lordship. Sure.
Lordship, I am for the petitioner.
Yes.
He is appearing for the state. He is engaged in other court minor and appearing for not to denounce.
Who is assisting him? What is the matter about? Let me hear once.
Actually, Lordship, the deed was produced, submitted for registration. It was pending for 17 years.
Deed.
Still,
Right.
And Lordship, I have deposited all the money, Lordship.
17 years it is pending?
Lordship.
What were you doing?
Lordship, that was moved before the Honorable High Court. High Court directed them to consider my representation. Thereafter, they have considered and thereafter they have assessed a huge amount. I have challenged that whether he has got the power, because after 4 years, he has got no power to reassess. That is the subject matter of challenge.
And
Lordship.
what happens if within the 4 years you do not pay up the assessed amount?
Lordship, then I have to be penalized. I have to pay. I have to penalized. But within 4 years, they have to reassess.
Very well, please come.
Okay.
The petitioner is aggrieved by the assessment order issued by the registering authority dated 21st November 2024. Stop. Paragraph. Let a report be prepared by the additional registrar of assurances. No, make it the registrar. Registrar of assurances. And circulated by 5th of March List the matter on 12th March.
Lordship.
Hello, this is my petition, my lord.
Order passed to aspect.
I am appearing on behalf of the respondent, my lord. Kindly, my lord, takes 2 weeks about times to file my
My lord,
affidavits, my lord.
already,
The whole matter, my lord.
my lord, in 2022, my lord, there was a direction for filing opposition. And my lord, this proposition is already settled. Coordinate bench had passed an order in our favor in another matter. Thereafter, my lord, that was confirmed by the division bench. They went up before the Supreme Court. That was SLP was rejected. Again, my lord, in contempt, they paid the money. It's related to subsidy, my lord. The issue is same. The entitlement of subsidy.
My lord, 3 matters, my lord. My lord, this entire, my lord, challenge before the, my lord, Chief Justice bench, my lord, honorable Chief Justice bench, my lord. My lord, kindly, my lord, 2 weeks time to file the affidavits, my lord.
No, no, there's order to
2022, the
order to judge ke do.
then
Judge copy da.
why? The incentive, the petitioner will receive some money from the state government. Is it a financial incentive or what? What type of incentive?
This is with respect to another, my lord. Same, my lord. I'm handing over, my lord.
This is the separate. The fulfillment.
Acha, ashun dekhi.
My lord, may I just hand over this order? This
So
is
show
with
it to your
respect.
learned friend. Acha, the
Same issue.
Issue is same. Subsidy.
affidavit in opposition as directed to be filed. Video order dated 19th May 2022 has not been filed till date. Stop. Learned advocate representing the respondents seeks respondent numbers 4 and 5 seeks extension of time for filing the affidavit. Stop. Learned counsel representing the petitioners submit that the issue has already been decided by the court. Stop. For ends of justice, time to file the affidavit in opposition is peremptorily extended for a period of how soon? 3 weeks. Reply, if any, within a fortnight thereafter. List the matter upon conclusion of the aforesaid time period.
My lord kindly fixes the date, my lord. After.
Immediately it will come. After the 3 to 5 period is over, it will come.
Much obliged, your lord.
Madam, for the petitioner, my lord, it's a tender matters.
Your name has not gone down.
Order dated 29/1/25 and 6/2/20.
None of the dates your is Mr. Dinda appearing?
Madam,
He is there, and you are appearing with him.
Here I am appearing.
Madam, Mr. Dinda, my lord, appeared with along with me on the
AG.
AG.
Yes. No, but that was
In all the matters.
in all matters. If she is
She
engaged,
is,
then
my lord,
her
she is,
name
yes.
ought to go down.
Na
Very
appear,
well.
my lord, she was there.
Very well, please come. ওনার নামটা দিয়ে দেবেন তো এর আগের দিন 29/1 আর 6/2 দুটো all right, it will be done.
But for reimposition of the interim order,
Reimposition of interim order. When did it
interim
expire?
order was there.
Interim order has expired.
Lordship, we have taken out an application saying that the interim order expired on 30th November. We have merely stated that we had tried to mention, but the matter could not be listed. Therefore, we are praying. Lordship, the short point here is whether an MSME, whether the MSME can be, whether the petitioner company could be considered to be an MSME since it got registered long after the contract.
Long
So
after?
the tender was.
All right.
At the
Lord-
relevant point of time, they didn't have certificate.
They did not have the certificate at the relevant point of time. Based on that, the Honorable Trial Court, the Honorable Judge was pleased to pass an interim order. Kindly comes to the interim order at page 9.
Yes, I see. If any arbitration has been initiated or the matter has been referred to, the same shall remain stayed. Has any arbitration proceeding been initiated?
Lordship, but they,
However, if the order has expired, we have filed an opposition.
we have not been received a
I have not received. Just fix the
opposite.
date and
Lordship, the entire matter will become infructuous if the arbitration proceeds. Lordship, that is the short point. Lordship decides the point.
Here and now the matter can be heard, Your Lordship. The opposition.
আমাদের রিপ্লাই দিতে হবে তো আমরা তো পাইনি
copy serve করুন।
you haven't served a copy
Without serving the opposition, without the reply, the matter can be heard in the to be mentioned stage.
copy serve করেছিল ও সরাসরি শর্ট কপি
কাকে সার্ভিস করেছেন?
Has it been served?
No.
Show it to them.
not to
No.
it has
Oh.
Directly serve the party, Your Lordship.
directly when they knew the advocate
Advocate on
was
record is
appearing.
there and you serve it to the party. Is this a system? Please come. Your Lordship, kindly don't extend the interim order. What can be done? The writ petition will become infructuous. This is the prayer for
We have
reimposition.
said it has expired. We have not suppressed.
It has expired on 30th November. They have
Yes.
initiative.
We have taken out this application. We
Keeps it next week, the matter can be heard.
But we are also not coming in the way of it being heard as soon as possible by your subject to your lordship's convenience.
Opposition, Your Lordship. And they will
We'll
not
have
look
to
into
have
it.
opportunity to reply.
Next, Lordship, kindly does not extend. Why? How are you prejudiced? Your Lordship, the arbitration cannot be, will not continue, Your Lordship. Yes, how are you prejudiced? Your Lordship, the arbitration has been initiated, Your Lordship. We will not be able to participate. Who are you? I am the one who initiated, Your Lordship, the arbitration. I will be the one who's prejudiced. No, but then how are you related? Lordship, there was a contract. Respondent numbers 3 and 5. I am 4, Your Lordship. Respondent number 4. Respondent number 4.
ঠিক আছে বলুক ও তো বলবেই। গভর্নমেন্টের কাছে ইনস্ট্রাকশন দিয়ে সময় লাগে।
The writ petition is the additional Director General of Police.
Lordship.
Yes.
What is the?
It's a contract of the Kerala government.
It's a contract of the Kerala government. Contract with whom?
With this man.
With respondent number 4, Your Lordship. It's a company, Your Lordship. Respondent number 4 is not the company. Respondent number 3 is the company.
Yes, 3.
3 is
4
the
is
company.
the
Is the
proprietor, possibly.
one of the directors.
Number 3 is the
Proprietor.
right.
Proprietor.
Proprietor. And is the assuming the arbitration clause is not there, what is the dispute redressal mechanism between the two of you? We are an
Not, then
the MSME the conciliation proceedings has been terminated. Thereafter, arbitration has been initiated by the MSME.
And we are even disputing that
they
it's
have
an
to
MS.
have a registration at the relevant point of time. Only then they can.
Who is for the respondent number 2?
Mr. Somnath Sen.
Yes, what is your stand?
They're not here in court, Your Lordship. And they asked if you can adjourn or because this was to be mentioned, Your Lordship, immediately.
My lord, give me 30 seconds and indicate the point of law, Your Lordship. Madam, it is their petition. They will start first. আচ্ছা লিখুন তো কি বললাম an application has been filed
by the writ petitioner seeking reimposition of the interim order passed by the court on 24th of September 2024. Stop. Learned counsel representing the respondent numbers 3 and 4 strenuously opposes the prayer for reimposition of the interim order. Stop paragraph. It appears that if the interim order is not reimposed, comma, the writ petition will become infructuous. Stop. Affidavit has already been filed by the respondents. Respondent numbers 3 and 4. Stop.
Yes, Lordship, the same has been served to the party. If this affidavit
May-
service can be taken on
Lordship,
record.
service with a special. State has not filed anything. MSME has not filed anything also.
No, MSME has filed their own.
There is an instruction.
Can we get another copy, please?
Yes.
3 and 4 praise for filing an opposition. But then 1 and 2 were not there also on the last occasion when the interim order was imposed. Achha. The stand of the respondent numbers 1 and 2 is also required to be considered. Stop. These respondent numbers 1 and 2 are directed to file a report by way of affidavit. Stop. Such report shall be prepared and circulated by 28th of February 2025. Stop. For interests of justice, the interim order, which was imposed on 24th September 2024, is reimposed, and the same will remain valid till 30th of April 2025. Stop. Let the matter appear in the list.
But may I have a copy of the affidavit in opposition that they have filed?
Yes. On 7th of March 2025.
And may I have a copy of the affidavit that they have filed?
Certainly, give a copy. Achha, it will be open for the petitioner to file exception to the affidavit prior to the adjourned date. Affidavit in opposition রেকর্ডে রেখে দিন, আজকে ফাইল করেছি।
একটা চিঠি করে দাও। ফোন নাম্বার নিয়ে দাও, কিছু দিয়ে দাও।
এখন দিতে পারবেন না?
না, আমার কাছে কপি দাও। নাম্বারটা দিও।
By this matter, I have been instructed by Mr. Shobhitindranath Ghosh. He is variously ill, sick. His medical report is carrying on his clerk. He is praying. He has instructed me to take 7 days time at least.
May I just,
For the petitioner?
I am for the,
here, India.
I am for the petitioner.
Who are you for?
My learned friend is for the railways.
Railways.
May I tell your lordship, your lordship might remember that
Can the matter proceed without the assistance of the learned counsel for the railways?
main authority. I'll tell, my lord, kindly give me only one moment. My lord, your lordship will remember that I had, my lord, challenged a tender saying that, my lord, I was the L1 bidder in a tender. My bid had been accepted. My lord, my lord, parties were negotiations finalized. Then, my lord, a fresh tender had been issued for the self-same item by the railways, which your lordship, my lord, ultimately said your lordship will hear the parties, and in the meantime said it will abide by the result. That is item number 5 in today's petition. My lord, this matter was allowed directly to appear along with, because my lord, this is the earlier writ petition in which I was the L1 bidder. Now, in this, my lord, my learned friends proceeded to serve the railways, and my lord, in the absence of the railways, I don't know why the railways did not appear, proceeded to, my lord, obtain an interim order which says that don't place any work order under that tender under which I am L1. Now, my lord, so far as that is concerned, my lord, that order was passed, my lord, initially on the 16th of May 2024, and thereafter was continued on the 1st of August. Railways represented to us, we are contesting the matter. And my lord, unfortunately, my lord, nothing has happened since then. Railway thereafter proceeded to, my lord, float a fresh tender, which we opposed before your lordship, which your lordship has considered. I am instructed that fresh tender has since been withdrawn after I filed the writ petition. Now, my lord, so far as this
So
is
your writ petition will become infructuous if it is withdrawn.
that's item number 5.
All right.
If, my lord, they have in fact withdrawn, my lord, I will of course wait to hear that from the railways. Then, my lord, that has become infructuous. My lord, the question is, my lord, unless, my lord, they can proceed with, my lord, this tender in which I am L1, my lord, they will again proceed to float a fresh tender. Now, my lord, I have to have this order vacated. My respectful submission is this order was obtained without making me a party at a date when they were aware that I was the L1 bidder. I had participated in the reverse auction. Thereafter negotiation, bid had been confirmed in my favor.
Lord, in other words,
My lord, let me, my lord, conclude. My lord, I have therefore, my lord, applied for vacating. Now, my lord, I had written to the railways. Railways has served on me an affidavit in opposition that they filed in the main writ petition. My learned friends, in spite of requests, have not served on me the main writ petition. Now, my lord, I have, my lord, found from the affidavit that the railways clearly states, my lord, what stand I have taken. My lord, that is, my lord, my learned friends have no right whatsoever, under, my lord, the previous writ petition, to, my lord, contend that their bid should also have been considered. There were 2 items. My learned friends were successful in 1 item.
Lord, may I
am successful in the
may
other.
I just indicate one
I
thing?
want to move my petition, my lord, on its merits.
Very well, but let the railways come. Otherwise, it will be difficult.
Well, my only apprehension is, my lord, railway, my lord, I'll tell you, lordship, my lord, kindly just consider one thing. My lord, 15th of May, the earlier writ petition was moved by my learned friend's client. Railway does not appear. 16th of May.
In which matter? Item 3. Which matter? Copy has not been served.
No, no.
Me, not us.
No, that is my.
Petitioner in item 3.
Have served, they've appeared after that.
You are the writ petitioner.
I am the writ petitioner.
You are the applicant.
Well, I am the
my
applicant.
writ petition, Mr. Shaha wants to be added.
Yes,
and
this
to
I
have
have
my interim order vacated. The railways had appeared. Railways had very heavily contested. It was heard by my Lord Justice Bhattacharya. Then again by my Lord Justice Sarkar.
Then you say
direction
copy
for
was
Railways have not contested at all.
They have filed an affidavit in opposition.
Railways have not contested at all.
No, I had appeared, my lord. That's it.
Railways had not pursued.
Railways had very heavily contested this.
The
It
order
had
does
appeared
not
before
reflect.
Justice Sarkar. Railways had contested the extension of interim order. After hearing me, the interim order was extended. I don't know if it will be reflected from the
Anyway, my
order.
lord, your lordship
But
will
I had
consider it.
appeared, Mr. Rajdeep Mojumdar had appeared for the railways that day.
May I say this?
For the union?
Well, if your lordship, my lord, wants to consider it in the presence of the railways, I have nothing to say. But, my lord, this matter will have to be considered on its merits now, my lord.
Very well, but let the railways come.
My lord, kindly fix a very short date, my lord, so that I may, my lord, proceed with this. Because my apprehension is railways will, my lord, if they can't proceed with this tender, they will again go to float a fresh tender.
Can I order sheet কোথায় গেল?
But apropos the fresh
Was any order passed?
no product. I'm sorry, Milan.
In item number 3, was any order passed earlier?
Yes,
my
there is
lord.
an
Well, if your
there is
lordship
an interim
sees,
order which
well,
was
may I show you
extended also.
well,
My lord,
3 pages.
it-
Please see, my lord,
first-
page 238 first.
First order is 16th of May 2024.
No, 15th May. First order is 15th May at page 238.
Oh, 15th May. 15th, then 16th May interim order, then 1st August against extended.
15th May, railways does not appear. 16th May, railways does not appear. 18th, 1st August, my lord, the matter is not, at least order reflects matters not considered on merits. It is simply, my lord, the order is.
The original side is chilo. It has been converted to the appellate side. The You appeared, Miss Burman. Your name is reflected in the order sheet.
On 1st August.
1st of August. And
But,
then
my lord,
you
the
say
interim
that
order.
the copy was not served. How can that be?
No, the order record service, my lord, on railways. 15th May, my lord, is the first order record service,
Yes,
non-appearance.
16 they don't appear. 1st
16th
August
also they don't appear, so it's
then
not
they
passed
filed
ex
an
parte.
affidavit. To that I have a reply.
My lord, most important is, my lord, on that date, my rights had crystallized. I am not made a
For
party.
that I'll address your lordship on, my lord, whether he has a right to intervene.
Whether do you want to file an affidavit in
Yes, my lord,
opposition to
this,
the
kindly keeps
application?
the, I'll file an affidavit. Kindly keeps the point of maintainability of the application also open. Because in my list, he is not somebody who can come in and seek this order. He's not a person interested. or a person aggrieved.
But that I shall always, but the only my lord request is kindly give very short directions for affidavits.
An application has been filed for addition of party. Stop. Learned counsel representing the petitioners oppose the same and seeks time to file opposition. Stop. Let affidavit in opposition be filed within a period of 2 weeks.
my lord, 2 weeks.
Reply, if any, within a week thereafter.
Kindly keeps the point of maintainability of the application open, my lord.
An issue has been raised with regard to the maintainability of the application at the instance of the applicant. Stop. The said point is left open to be decided at the time of consideration of the application.
Great.
My lord, may I only pray that this.
It is up to you.
And opposition is serial number 5.
No, this is item 3 going on.
Lord, could I reply to
To
the
the-
opposition of the
Yes.
railways? which are
Railways,
on record?
yes.
Thank you.
The affidavit in reply to the opposition filed by the railways. We retain with the records.
My lord, may I only pray that my lord, this matter be my lord kept my lord in a position that where it can be heard out. I know your lordship's my lord difficult.
Very difficult. And item number 5, what to do? It has become
Item number 5, my lord, if my learned friends say that they have my lord withdrawn that tender, then my lord naturally I can't my lord ask for
Lord,
anything. more.
5, I am not involved. I'll take your lordship's leave. 5, I am not there.
There.
Then may let it be recorded.
Please come. Item number 5 একটা order লিখুন তো।
5 এ তো আমরা নেই।
Learned counsel representing the railways submits upon instruction that the tender in question has been cancelled by the authority. Stop. In view of the above, nothing survives to be decided in the instant writ petition. The writ petition stands disposed of. Call 4.
My lord, affidavit in service in both the matters.
Yes.
Affidavit in service.
My lord, item number 4, my lord, is my petition.
Yes.
Appearance.
Oh. Item number 4, your lordship might recall, my lord, this is the question of my lord whether my lord, the tender term could have been modified after my lord the parties had entered the fray and made their bids, but the question of the arbitration clause. My lord, my learned friend was supposed to take instructions and come back.
Yes.
I was told, my lord, that it has been, my lord, published in the official website, my lord, and I was told on instruction, my lord, that verbal communication was made to them, my lord, with regard to that notification, and everybody knows about that notification. This is what, my lord, impressed upon me, my lord.
Absolute verbal communication.
Absolute verbal communication, because it has been gazetted. They have said it has been gazetted, so it has been widely circulated. As per
Correct.
lordship has knows, my lord, that
Yes.
that analogy, my lord.
Now
My lord, now, my lord, I will show to his lordship on the last occasion. I said to his lordship, he shall come up with some judgment so that, my lord, I can apprise to his lordship. Now, first is, my lord, with regard to, my lord, whether this writ petition is at all maintainable before his lordship is or not, my lord. Now, my lord, may I hand up, my lord, 2000 volume 6 SCC page 293. This is a copy. এই এটা জজ সাহেবকে দিন এই দাদা আমার
Mark copy.
my lord, that is a mark copy. Can you take this, my lord? এই take ওটা mark.
ওটা ফেরত দিয়ে দিন। Yes.
Now, my lord, kindly see, my lord, paragraph 10 prior to that, my lord, paragraph A, my lord, Article Constitution of India, Article 226, maintainability. Alternative remedy, exhaustion of the remedy. Dispute relating to the terms of contract with statutory body. Held, writ court not ordinarily the proper forum for resolution of. Further held, a contract does not become statutory simply because it has been awarded by a statutory body for the construction of a public utility. Now, my lord, kindly takes paragraph 10 of this my lord, this judgment, my lord. Paragraph 10, my lord, may I just read, my lord? We find there is a merit in the first contention of Mr. So-and-so, learned counsel has rightly questioned the maintainability of the writ petition. The interpretation and implementation of a clause in a contract cannot be subject matter of a writ petition. Whether the contract emphasized actual payment or not is a question of construction of contract. If a term of a contract is violated, ordinarily the remedy is not the writ petition under Article 226. We are also unable to agree with the observations of the High Court that the contractor was seeking enforcement of a statutory contract. A contract would not become statutory simply because it is for construction of a public utility and it has been awarded by a statutory body. We are also unable to agree with the observations of the High Court that since the obligations imposed by the contract on the contracting parties come within the purview of the Contract Act, that would not make the contract statutory. Clearly, the High Court fell into the error in coming into the conclusion that the contract in question was statutory in nature. Next is paragraph 11, my lord. A statute may expressly or impliedly confer power on a statutory body to enter into contracts in order to enable it to discharge its functioning. Dispute arising out of the term of such contracts or alleged breach have to be settled by the ordinary principle of law of contract. The fact that one of the parties to the agreement is a statutory or public body will not be itself affect the principle to be applied. The dispute about the meaning of a covenant in a contract or its enforceability have to be determined according to the usual principles of Contract Act. Every act of a statutory body need not necessarily involve an exercise of statutory power. Statutory bodies, like private parties, have power to contract or deal with the property. Such activities may not raise any issue of public law. In the present case, it has not been shown how the contract is statutory. The contract between the parties is in the realm of a private law. It is not statutory contract. The dispute relating to the interpretation of the terms of the conditions of such contract could not have been agitated in a petition under Article 226 of the Constitution of India. That is the matter for adjudication by a civil court or in arbitration if provided for in contract. Whether any amount is due and if so, how much, and refusal of the appellant to pay it is justified or not are not the matters which could have been agitated and decided in a writ petition. The contractor should have relegated to the other remedies. This is one judgment. Secondly, my lord, so far this judgment of 2000 volume 6 SCC 233 is concerned, this has been affirmed, my lord, in my lord 2021 volume 10 SCC page 690. Here, my lord, the same question of maintainability was raised, my lord. And my lord, may I take his lordship to paragraph 18, my lord. Paragraph 17, my lord, that which I have, my lord, read just now, my lord, that has been set out in paragraph 17, my lord.
Yes.
And paragraph 18, my lord, will see, my lord. Mr. Swanso placed reliance on the judgment of this court reported in Joshi Technologies International Inc. versus Union of India, wherein the following was held Swanso. Law in this aspect has developed through a scatina of judgments of this court, and from the reading of these judgments, it would follow that in pure contractual matters, the extraordinary remedy of writ under Article 226 and or Article 32 of the Constitution cannot be invoked. However, in a limited sphere, such remedies are available only when non-governmental contracting parties is able to demonstrate that it is a public law remedy which such party seeks to invoke. In contradiction to the private law remedy simpliciter under the contract, some of the case law is bring home this cardinal principle is taken note in hereinafter. Thereafter, my lord, the judgments has been referred to, my lord, in my lord, page in clause in 69, my lord, in one of the judgments, my lord. 69, my lord, kindly takes, my lord. The position thus summarized in the aforesaid principle has to be understood in the context of discussion that proceeded which we have pointed out above. As per this, no doubt, there is no absolute bar to the maintainability of the writ petition, even in contractual matters or where there are disputed question of facts, or even when monetary claim is raised. At the same time, discretion lies with the High Court, which under certain circumstances it cannot refuse to exercise. It can exercise. It also follow that under the following circumstances, normally the court would not exercise such a discretion. Then 16.1, my lord, the court may not examine the issue unless the action has some public law character attached to it. Next, my lord, 69.2, whenever a particular mode of settlement of dispute is provided in a contract, the High Court would refuse to exercise this discretion under Article 226 of the Constitution and relegate the parties to the same mode on settlement, particularly when settlement of dispute is to be resorted to through the means of arbitration. 69.3, my lord, if there are very serious disputed question of fact which are to be complex nature and require oral evidence or for their determination. Now, my lord, here, my lord, the things is that, my lord, in 2011, my lord, in the contract, my lord, arbitration clause was there, and after, my lord, proceeded with that, and before the issuance of work order, that arbitration clause has been withdrawn, my lord, and that has been gazetted in the public notification. And, my lord, this is, according to me, my lord, is a disputed question of law and facts, because
Which one? Where is the dispute? You have gazetted it.
yes, I have gazetted it. Now they says, my lord, that we do not know. In 2023, they issued a letter in trying to invoke arbitration, and in reply says, my lord, that gazette notification is already there. So this is according to us, is, my lord, there is a disputed question of law and facts, my lord. We do not know, my lord, and the fact is that, my lord, it has not been communicated, they told, but I was told, my lord, since it has been widely circulated in the gazette notification and in the website, so it can be presumed, my lord, everybody knows, my lord, that arbitration clause is no more there. And not only that, my lord, the petitioner is working since 2011 to 2020. So 9 years they are working on the contract, my lord, and it cannot be believable that they do not know that the arbitration clause is no more there. And on the same analogy, my lord, precisely on the same point, my lord, Madhya Pradesh High Court has, my lord, a decision, not Supreme Court, my lord. A Madhya Pradesh High Court, my lord, 2024 SCC Online MP 7383, my lord. Here, my lord, if his lordship, paragraph 3, my lord, learned senior counsel appearing for the petitioner submits that the arbitral tribunal has inherently lacked jurisdiction to entertain the claim for the reason that there is no arbitration agreement between the parties. It is contended that though an arbitration clause was incorporated in the original contract dated 1/1/13, excluded between the parties subsequently by an addendum dated 25/1/2016, said clause was deleted from the agreement. Here, my lord, the same thing has been happened, and it is not done within 3 years, but it has been done prior to issuance of work order and letter of acceptance, my lord. Now, my lord, in paragraph 19 of this judgment, my lord, may I just read, my lord? Petitioner not only reiterated its stand that the addendum dated 25/1/2016 deleting the arbitration clause was not operative and the arbitration clause continued to exist. It even invoked arbitration, reiterated its stand for referring disputes to arbitration, and then approached the High Court for appointment of arbitral tribunal, and even submitted its claim before the arbitral tribunal. Thereafter continued to participate in the arbitration proceedings. Petitioner never raised any objection either before the arbitral tribunal or at the time of filing of its objection under section 34 of this act that the arbitration agreement stood deleted. On the contrary, petitioner at all stages negated the contention of the respondent that the arbitration clause stood deleted. Since 25/1/16 till 26/9/2024, nearly 9 years, the categorical stand of the petitioner had been that the arbitration clause exists, and the petitioner has all along acted upon the arbitration clause without any demur. So here, my lord, it's a 2011 arbitration clause is no more. In up to 2020, he has worked. Thereafter, COVID. Now 2023, he write a letter by invoking arbitration clause, and it has been dealt with by the authority concerned by saying that in 2011, prior to issuance of work order, the arbitration clause is no more. So here, my lord, the analogy is the same principle is followed, my lord, in this judgment also, my lord. And in paragraph 21 also, reference under section 7 has been referred to, my lord, has been referred to. There are certain clauses. Now I am relying on clause D. B, sorry, my lord. Clause B, my lord. Clause 4B. An exchange of letters, telex, telegrams, and other means of telecommunications, including communication through electronic means, which provided a record of the agreement. Here, my lord, I have all along said before his lordship that it has been gazetted. So, my lord, it has been publicly published in the official website. So it has been widely circulated. So we can safely say, my lord, that communication through electronic means which provided a record of the agreement. So, my lord, hence, my lord, there is no question of any arbitral dispute between the parties. And if he is so aggrieved at that point of time, my lord, he should have come up early before this court, my lord, for seeking, my lord, appropriate remedy before his lordship, my lord. And lordship knows, my lord, this is their claim damages and money suit is there, my lord. That's all, my lord. That is my lord.
Lord, as your lordship, my lord, might remember, I'll just refresh your lordship's memory. Notice inviting tender containing the arbitration clause floated on the 6th of January 2011. My bid is made on the 19th of May 2011. My bid is accepted and I'm declared the L1 bidder on 28th June 2011. Now, my lord, thus far, my lord, there was no dispute with regard to the arbitration clause. The arbitration clause, my lord, is omitted by a notification of 13th December 2011. Thereafter, my lord, my learned friend says that, my lord, I was aware of it. I should have been aware of it. I'm deemed to be aware of it. My lord, my learned friends, my lord, call upon me to extend the validity of my bid. My lord, that is, my lord, after the notification has been withdrawn by a letter of 25th January 2012, which your lordship will find at page 111. There is no mention of deletion of the arbitration clause. My lord, this in fact refers to the NIT, my lord, but no mention that the NIT has been modified or altered. My lord, thereafter, my lord, they extend the scope of the work under the tender, my lord, which is, my lord, on the 3rd of February 2000 December. Even then, they don't say that now the work is extended, the scope is expanded, but the arbitration clause is deleted. I'm putting you on notice. Nothing. Thereafter, my lord, the letter of acceptance is issued on the 3rd of March. Work order is issued on the 14th of February and 3rd of January and 14th of February, etc. Well, I complete the project in 2020. Thereafter, my monies are not paid. I raise a dispute. When I raise a dispute, they say that no, there is a notification of 13th December 2011, arbitration clause deleted. Now, my lord, here I had shown your lordship one judgment of the Supreme Court, but my lord, there are scores of judgments which goes on to say only one thing. Once a notice inviting tender is, my lord, published and you're, my lord, invited to make a bid, which is an invitation to treat, it is an invitation to offer, you're invited to make a bid on the basis of the terms of the notice inviting tender, the rules of the game cannot be changed thereafter. My lord, one judgment, my lord, which I had shown, my lord, is very expressly on the terms, but my lord, there are other judgments of our High Court, of the Supreme Court, of my lord, different High Courts, which clearly says you cannot alter the terms of the notice inviting tender, except, my lord, in extraordinary circumstances. Now, my lord, arbitration clause is, my lord, an inherent part of these agreements. My lord, it is the dispute resolution clause. And, my lord, it is an important part because in these contracts, my lord, it is envisaged that there might be disputes which arise in the future. And, my lord, that is why the provision for dispute resolution. Now, you suddenly say, I shall omit that entire clause for dispute resolution. Well, the first question is a legal question, can it be done? The second question, within my respectful submission, is not really material, is, my lord, were you informed? My learned friend says, my lord, there is no, my lord, information except an oral intimation of which there is no record. My learned friend says that merely because it was gazetted, you are deemed to have, my lord, knowledge. My lord, at least, my lord, in the communications that have followed in the course of, my lord, the execution of the contract, modification of the contract, my lord, scope, my lord, invitation to keep the bid extended, my lord, there is no intimation. Now, my lord, it's a question of law. Can you therefore, my lord, say that after you have accepted, made your bid and have accepted your bid, I can suddenly change the rules of the game? Well, I had shown your lordship, my lord, a judgment of 2015, volume 16 Supreme Court cases.
Vertex.
Yes. Well, lord, may I just, my lord, refresh your lordship's memory on, my lord, the principal terms? Please have a look at paragraph 1. Just a few paragraphs to show your lordship as to how emphatic this judgment is. And, my lord, there are other judgments of the Supreme Court and the High Court also. My lord, please see, my lord, paragraph 1. My lord, here your lordship will find, my lord, the fourth line, action of the Union India in forfeiting or withholding reserved license fee, which was deposited by the respondents as condition for their bids in obtaining FM broadcasting license. According to the licensees, there was a unilateral departure by the Union of India from the terms of the tender document, which had surfaced from the LOI was issued on such and such. Then, my lord, skipping over, my lord, 2 lines, then your lordship still read, the contention before the High Court was to the effect that in view of the aforesaid unilateral departure, the Union was in breach of the tender conditions. This apart, it was also contended that in the absence of any specific clause in the tender document permitting forfeiture or retention of the license fee, the action in this regard was wholly unjustified. Then, my lord, paragraph 3. Learned single judge of the High Court dismissed the writ petitions filed by the licensees on the ground that the departure from the conditions of the tender document as made in the LOI and the draft license agreement were not of significance. The learned single judge also took the view that retention or forfeiture of the amount by the Union would be justified as the action of the licenses in refusing to act in terms of the LOI granted to them had occasioned loss to the Union. The licensees carried the matter in appeal before the division bench of the High Court. The division bench reversed the view taken by the learned single judge inter alia on the ground that departures from the terms of the tender document were major in nature.
Yes, there is no requirement of going
Yes, now, my
through
lord,
it.
this law is very well settled. Paragraphs 8 and 9, my lord, are very significant. My lord, or my lord, paragraph 9, my lord, this clearly, my lord,
Yes.
lays down the law.
Just tell me one thing.
Yes.
Now an issue has been raised by the state that it will not fall within the public law realm.
My lord, now, my lord, when we are talking about tender, I'm not only saying that this is a statutory contract.
Yes.
That is not my contention.
Right.
Now, my lord, if it is statutory contract, immediately, my lord, the public law element surfaces. Now, my lord, when, my lord, a contracting authority is the state, and my lord, this is tender floated by the state, then, my lord, in the matter of issuance of tenders, your lordships have intervened, my lord, countless number of times. My lord, now the question is whether the action is arbitrary. My lord, this is an arbitrary and unilateral, my lord, change or, my lord, moderation of the terms of the
Very
original
well.
tender. That is
Nothing
all.
more. Yes, please come.
ठीक है,
Hearing concluded, judgment is reserved.
Grateful.
Well, I am for the petitioner. Well, I think there's a bona fide mistake in listing the matter. Your Lordship direction on 16 January, the corporation take up the matter today at 12 noon. Then, my lord, why I fail to understand why it is listed here. I have not mentioned the matter, my lord. And this is the last order, 16 January, paragraph 4.
This was not supposed to not fixed before your lordship today. It was fixed before the corporation.
Jana Babu. Has been fixed because this is my
My lord has
practice.
fixed it for hearing before the corporation at
Yes,
12.
I never fix up time because it is very difficult to maintain the time. Wrongly appeared in the list. Yes, call 7.
7 I appear here.
Lordship, on the last occasion, my lord, as I have said, my lord, that I will file the report before his lordship. That is with regard to the city civil courts matter, my lord, wherein
Yes.
his lordship has, according to the petitioner, my lord, the records are not traceable. So, my lord, a report has been filed, my lord, in this regard, my lord. So, my lord, if lordship
Are the
takes,
reports traceable? The records
no, my lord,
traceable?
it says, my lord, that the concerned registry, my lord, have requested the concerned learned benches for providing details of the status of those cases and annexing the request letters that has been annexed. So far, these cases are concerned, my lord. First case, their miss case number 731599 was transferred to the second bench, City Civil Court. Remaining 3 miss cases were numbered miss case so and so were transferred to the learned 8th bench, City Civil Court. I am annexing here in the copy of the report of the COA along with the copy of the register of Seresta Lanet City Civil Court Chief Judge. Now, my lord, this is the letter and, my lord, some documents has been annexed, my lord. Now, only things is that, my lord, kindly takes, my lord.
7315 records were destructed and the matter was disposed of on 11th of
Yes, my
March
lord.
2014.
Dealing assistant Seresta, second bench informed the record in connection with Miss Case 731599 was destructed and the matter was disposed of by the concerned court on 11/3/2014.
If it
Copy
is
of the
so,
report along with.
if it is so, then the soft copies must be available.
I don't think, my lord, in 2011 or 2014 the soft copies were
Then
there.
if the record is destructed, how will the party get to know of it?
But
you
it has
cannot...
been mentioned, my lord, that the status of the CIS has been, my lord, and ache CIS annex করেছে.
No, status is something else. Status will say only whether it has been disposed or
Yes, my lord.
whether it has been dismissed for default. Something is mentioned, but then you cannot destruct.
Because now, my lordship knows, but after considerable period of time, my lord, if the record is dismissed for default or disposed of with certain period of time, the record has been destroyed.
Maintaining soft copies.
But, my lord, that is then, my lord, I have to, my
It
lord.
can never be that all records are destroyed and you cannot have a copy. This can never be. And it is
Now,
not
my lord,
very far back. It's only 2014.
2014.
Matters are pending for years together.
Yes, my lord.
It can never be. You take further instruction.
I shall.
And the other matters, they are
They says, my lord, the
time
with
for
the
searching.
inform the records in connection with Miss Case prayed for time for searching those records.
Yes.
So, my lord, I shall, can you fix a date, my lord, so that I shall next time I shall try to, my lord, I have already told them, my lord, to bring out all this, and so that at least, my lord, something should be made before his lordship, so that I can
The
apprise before his lordship.
petitioner,
Yes,
the
my lord.
petitioner wants to proceed with these cases.
Also,
Wants
my
to
lord.
know what is the fate of these cases.
Now, one thing is, my lord, one matter is, my lord, found, my lord, that 11/3/2014 that has been dismissed, disposed of. But so far, remaining 3 matters, my lord, but
Even
this
that
matter
also.
also, my lord, I will instruct them, my lord, whether any soft copy is there.
May I have a copy of the report, my lord?
Yes, yes, give it.
Copy is-
The registrar, City Civil Court, Calcutta has forwarded a report dated 11th of February 2025, mentioning that Miss Case number 7315 of 1999 has been reported to be destructed by the dealing assistant Sherestha of the learned second bench, and the matter was disposed of by the concerned court on 11th March 2014 as appearing in CIS. Stop. As regards the other matters, time has been sought for searching the records. Stop next. As time has been sought for, the matter stands adjourned till 12th March 2025. Stop. An updated report shall be placed before this court on the adjourned date. Stop. The registrar shall also inform as to whether soft copy of the Miss Case number 7315 of 1999 has been maintained or not.
My lord, may I pray for one indulgence? Instead of 12th, any other day.
13th, lordship.
13th.
Subject to lordship.
Subject to lordship.
17th of March.
Lordship. Can you indicate that, my lord? So on the next date, my lord, positively, my lord, otherwise, my lord, it would be easier for
Yes,
me.
I have mentioned updated report to be filed by the registrar.
একটা copy
She will say that.
I am for the petition lordship in the matter of electric
My lord, I'm
supply has
praying for
been
a very
affected.
short passover, my lord. Mr. Naik is on a legs in courtroom 1. Very short passover, I'm praying, my lord.
Now, lordship,
Wait.
connection has been affected, lordship, to the petitioner, and we have informed lordship that they have prepared an appeal.
They have preferred appeal.
We have prepared an appeal today also.
Let
It is
the-
lying in the list court before the cause list of the Honorable Chief Justice, my lord.
Let the writ application be disposed of, lordship. If they prefer an appeal, got an order, lordship, that will be abided by the result of the
Electric connection will abide by the result of the writ of the mandamus appeal.
Oh, this is a husband-wife dispute.
husband-wife matter.
আচ্ছা, ঠিক আছে, লিখুন। Learned advocate representing the petitioner submits upon instruction that the electricity connection has been given to the petitioner. Stop. Paragraph. In view of such submission, nothing remains to be decided in the instant writ petition. Stop. The writ petition stands disposed of. I am not recording anything. The division bench is there. We'll
Whatever.
take steps. একটা লাইন শুধু লিখে দিন তো। Be it recorded that the
28th
supply of electricity will not grant any equity or right in favor of the petitioner in respect of the subject premises.
Oh.
Yes.
In 8, my lord. My lord.
In that one,
The line, your lordships,
in that one, I have
Eight,
recorded
eight.
that no
The
equity
last-
will be created.
9 my lord, last order of 28th January 2025. That has been complied. No, my lord,
I'm for the trade in this matter.
but the meter installed and my lord, the connection also given.
Photograph also.
So far,
What about
paragraph
the
number
contempt
4.
proceedings?
Yes.
You have deliberately
Exemption, my lord, from filing, my lord. My lord, she is an uneducated lady. My lord, after much persuasion, my lord, I got her my lord, to understand, my lord, what would be the consequences. My lord, she is praying, my lord, for exemption, my lord, from filing affidavit.
please come. Learned advocate representing the petitioner submits that the electricity connection has since been effected. Stop.
Six.
Learned advocate representing the district engineer, Calcutta South District, CESC Limited, files a compliance report signed on 5th February 2025, mentioning that a metered supply in favor of the petitioner was effected on 5th February 2025 by installing a new meter at the existing meter board. Stop. Paragraph. The grievance of the petitioner regarding supply of electricity has been redressed by the authority. Stop. Paragraph. There was a direction passed by this court on 28th January 2025, directing the private respondent to file affidavit to show cause as to why proceeding under the Contempt of Courts Act shall not be initiated against him.
Har.
আচ্ছা, ওটা হার হবে। Paragraph. Learned advocate representing the private respondent.
6 only.
Oh, there were 2. You are for 6. আচ্ছা, তাহলে হার হবে 6. Respond number 6. 6 also it's mentioned son of. See?
My client's
Madhavi Ojha, son of. আচ্ছা, হার। Yeah.
son of Sudhir Mondal.
Respond number 6, prays for apology and submits that the respondent number 6 is an illiterate, uneducated lady, and she did not properly understand the direction passed by the court. Stop. Prayer has been made to exempt her from filing the show cause. Stop. Paragraph. The apology tendered by the respondent number 6 is accepted by the court. Stop. The writ petition stands disposed of.
I'll oblige.
I am for the petitioner.
You are for the
Petition. Yes. And on the last occasion, there was a direction that the matter relates to the disbursement of a second loan. The petitioner is a BDS student, my lord. And my lord, my instruction presently is that the petitioner and the bank, they are not now in talking terms. They are talking about the how this second loan can be processed between them. So my lord, what I am seeking, maybe a short date may be given. Let them come to a decision if that can be adjusted, and subsequently my lord may pass an order. This is my last instruction, that the bank and the petitioner, they are on a talking term. They have exchanged mails. So this is my last instruction.
Lordship's direction has been complied. Lordship has directed on
28th of
17th January. Lordship has
So that is all right. After 28th, she says that
Lordship, she is not cooperating the bank. Your
she is
Lordship.
not cooperating.
Not cooperating.
Very well. Please come.
my instruction.
Learned advocate representing the petitioner submits that the that steps are on for settlement of the issue amicably between the parties. Stop. Learned counsel representing the bank submits upon instruction that the petitioner is not cooperating with the bank at all.
Lordship.
Stop. Paragraph.
Lordship, this is the letter
The-
issued by the bank to the petitioner. Kindly see.
The court, in order dated 28th of January 2025, specifically directed the parties to cooperate so that the second loan may be processed in favor of the petitioner. Stop. Paragraph. The petitioner is directed to cooperate with the bank for the purpose of processing the loan. Stop. On the request of the learned advocate for the petitioner, the matter stands adjourned till 5th of March 2025.
Grateful, ma'am.
Instruction forwarded by the branch manager of the bank be written with the records.
I appear on behalf
This matter I am appealing on behalf of the respondent number 1.
On your occasion, your lordship, the
My lord,
speech
I
to
beg
judge.
to appear for respondent number 2 and 3, Life Insurance Corporation. My lord, may I be
Any
permitted?
affidavit?
My lord, we are filing our. My lord, will kindly take up 11 and 12 together. My lord, I'm filing
Yes.
my report on affidavit, my lord, for both the matters. Dada,
Yes.
it has been served.
Do you intend to file an exception?
No, my lord,
No.
we have received the payment. After we filed
Payment?
the writ applications, my lord, they have paid the amount.
So
On
no
first
grievances now.
No, on 1st November, they have paid the amount. But on 25th November, when we moved this application before your lordships, they didn't say anything about the payment. And they are harping on the no annuity could be
So
paid.
right now you do not have any grievance.
Do not have any grievance, my
Please
lord.
come.
My lord, on admission, my lord, their award, I mean the ombudsman award should be set aside. And it should be allowed. That's my humble prayer before you.
What order did the ombudsman pass? Which
My
page
lord,
do
at
I get
page
it?
43 of both the petition, first is
43.
Prabha Sharaf, item number 11. They didn't mention anything about the payment. After filing the writ application, my lord.
Please, Liginenta, the
My lord, only thing, my lord, may I humbly indicate once, my lord, if the writ is allowed, then that would tantamount to again paying them the same amount. Because there are prayers for disbursing the annuity that was deducted from them, which now they are admitting has been cleared.
No.
Yes, what remains?
Our payment, our demand was 1,36,000. After TDS, my lord, they have credited to our account 1,24,000, my lord.
So
That has been admitted.
full and final settlement. There is no
My lord,
question.
nothing remains in the writ petition, my lord. My lord, nothing remains, my lord. Subject to correction,
Yes,
my lord.
nothing remains. So the what will happen to the order of the award of the ombudsman?
Ombudsman, correct.
You did not comply the order of the ombudsman. He challenged it. In the meantime, you have
Ombudsman did not order for the payment. After
Yes.
filing the writ application.
Ligunta,
This
The
ombudsman award. should
award
go.
passed by the insurance ombudsman was under challenge in the instant writ petition.
Next second, sir.
The ombudsman dismissed the complaint of the petitioner without providing any relief. Stop. After the writ petition was filed, the Life Insurance Corporation granted relief to the petitioner. Stop. Right now, the petitioner does not have any grievance against the Life Insurance Corporation,
Correct.
and his claim has been full and finally settled by the Life Insurance Corporation. Stop. In view of the above submission, nothing remains to be decided in the instant writ petition. The writ petition stands disposed of.
Much obliged.
And the award passed by
affidavit.
the ombudsman should be set aside.
Acha.
The question has been put.
কি বলে affidavit নাকি
And we
যেটা
have
আছে
questioned the
রেখে দিন।
award of the ombudsman, my lord. That should go.
In both the matters.
Same order in both the matters.
Much obliged, my lord.
I'm grateful. Another appearance to be?
I appear for the respondent.
Which respondent?
I appear for the petitioner.
Which
The team-
respondent are you appearing for, madam? Which respondent?
Respondent number 1, Your Lordship.
1, Union of India.
Yes, Your Lordship.
My lord, we made
Last of
Oh,
the
la-
Lordship has directed me, my lord, to file a report by the principal secretary. That has not yet been reached to me, sir.
The parties are getting delayed. They want to avail the benefit of cert.
That is there. I
Then
specifically told them everything so that, my lord, the report should be with my hand, my lord. But till now, my lord, I have not received that report. Can you give me 7 days time? I shall come back to it. It's just other issues. IVR Lordship has decided. This is only surrogacy. That is the whole
whether
issue.
the
That's
same
why
principle can be accepted or not.
asked for a report from the I have already intimated them. On the
What
same
is the age? What is the age of the couple?
my lord, 55.
55, husband.
55, 50.
No, below 50.
Below 50 is wife is below 50 and he is
Husband has
55.
crossed the
Yes,
limit.
just 1 month.
That's 1 month.
1 month on the day, my lord, when
Oh,
this
the
was
maximum age limit is 55.
So recorded on the
my lord,
What
Delhi
to
High
do?
Court. My lord, Monday it is possible.
Monday, 7 days. Monday, sir.
No, my lord, I tell your lordship, it is true, my lord, that the principal secretary of the Department of Health, my lord, is extremely a busy person. But my lord, I as a my lord, individual, this my lord,
Absolutely.
my lord, my lord,
He is losing age day
no, my
by
lord,
day.
only my lord, he is in predicament. Only my lord, 2 days time, I think, my lord, if he can pursue, my lord, Mr.
Please come.
Postum Malik is a very powerful man, my lord. He can-
On the prayer of the learned advocate representing the state respondents to obtain instruction from the principal secretary, Department of Health and Family Welfare. The matter stands adjourned till next Wednesday. I'm keeping it 19th.
19.
In the event next Wednesday.
My lord,
Today is
18th and
12th.
19th, possibly, my lord, I'll be in Tripura any day.
Online.
কুম্ভ যাই না আমি কুম্ভ টুম্ভ যাই না
Online.
ত্রিপুরা in Tripura my lord, this is a very difficult situation.
Difficult.
Very difficult.
When 20th? আচ্ছা 20 তারিখে করে দেন। আর
I may be
in the event the report of the principal secretary is not available on the adjourned date, then the principal laid down by the court in the matter of Shamuli Shaha and another versus State of West Bengal and others shall abide by the shall follow.
I'm deeply obliged.
Lord, I'm appearing for the petitioner. Lord, this matter appeared on 27th of January. Lord, your lordships had directed us to, my lord, file a supplementary affidavit bringing on record one particular document and also serve upon the respondents, my lord. But may I file the supplementary affidavit and the affidavit of service? I'll get a copy supplementary. Let me see. Lord, this was a matter, if your lordship recalls, Lord, the petitioner is a successful auction purchaser in respect of a property which is, my lord, situated at Jharkhand. Lord, a SARFAESI proceedings was initiated against the borrower. My lord, the property possession was taken under section 13(4). My lord, property auction, I became the successful, my lord, the bidder and was declared as the auction purchaser. My lord, now few dates are very important. My lord, on the date for auction was 24th of August 2022. My lord, I was declared as the highest bidder and I deposited a sum of 2.83 crores. My lord, on 25th of November, after 3 months, I made a request to the respondent bank to issue a sale certificate in my favor. My lord, when after 3 months, I was being made aware that the borrower had initiated a proceedings before the DRT, my lord, the Debt Recovery Tribunal, and had obtained a stay order. My lord, pursuant to which, my lord, the sale could not be confirmed in my favor. My lord, 3 months, no communications made by the bank. My lord, thereafter, I have annexed series of.
You want the money back?
I want the money back, my lord. And this has been admitted by the respondent, my lord, by way of writing an email, which I have disclosed in the affidavit, my lord. Despite such.
What is the stand of the bank?
Issues here. Only one first issue is that there is a SARFAESI application pending before the General Tribunal below, DRT.
No, that is by a different person for a different reason.
May I have 2 seconds, madam? The SARFAESI application has been filed by the borrower, in which the auction purchaser has been added at party to there. They chooses not to appear there. Can you see this order, madam? This is the auction purchaser, this is a necessary party, so court has added them as a party respondent therein. So they can canvass their grievances there, firstly. Secondly, kindly see the supplementary affidavit filed by them today. Kindly see the annexure there, my lord. Last line. This is what we agreed to.
Last line of?
The supplement annexure filed by them in
Annexure
today's
filed.
supplementary affidavit.
Yes.
Upon a wide request letter dated so and so, wherein you have sought refund of only sale consideration amount of so and so, bank has approved your refund request. We request you to confirm the same by sending a scanned copy of the cancelled check of your account in which you want to credit a sum of rupees so and so and so. So we agree to that.
But today, my lord, my claim, my lord, despite, my lord, there are correspondence going on since 2023. Despite such agreement, my lord, this payment has not come in. And my lord, I am also claiming.
Did you forward the cancelled check?
Yes, my lord, it is forward. I have annexed that particular, my lord. Kindly says page
Why is the
42
bank
of my writ
refunding
petition.
money?
No, he is asking for the interest.
My lord, refund
That
along
the
with
bank,
it.
my lord, they have.
You are enjoying the money
Yes.
for quite some time.
Yes.
Why will you not pay interest?
The reason being, my lord, the SARFAESI application pending, and we are debarred from handing over the physical person as well as the sale confirmation because there is a stay from.
No, it's all right. But then the person who has deposited his money, not getting the property, you are enjoying his money. Why not grant him interest?
We are ready to give him the money.
Why not the interest? Because you are holding it back for quite some time.
Because there is a reason that we this is not my, as per my choice. We do not, I cannot hand over the money along with interest because there is no lacuna on the part of the bank.
You may not be any lacuna, but you are enjoying interest on the same. What are you doing with the money? You are using it.
No, I'm not. I kept it in only an account.
You nolly an account, the money is of the petitioner. Had it been with him, he would have earned interest. Then why will you not pay interest to the petitioner?
Because the issues
Please
are
come.
pending.
No, sorry, sir. You cannot do this. Since when the money is with the bank?
But it is, my lord, from 24th of August 2022.
August 2022, you participated and you were declared as the highest bidder, but did you deposit the money on that day? Maybe a part payment was made? Deposited the balance on 23rd of November 2022?
But an upfront payment was made, my lord. Thereafter, my lord, the full payment was
Yes.
made in November. I stand corrected on that.
Right. The petitioner is aggrieved by the act on the part of the bank in not refunding the sum deposited by him for purchasing a property on auction under the provisions of the SARFAESI Act. Stop. The petitioner participated in the bidding process and was declared the highest bidder on 24th of August 2022. Stop. An upfront payment was made by the petitioner for participating in the bidding process. Stop. He deposited the balance consideration on 23rd November 2022. Stop. The property, however, could not be handed over to the petitioner because of a litigation pending before the Learned Debts Recovery Tribunal.
There is a stay also.
And an order of stay was passed by the tribunal, restraining the bank from handing over possession of the stressed asset. The petitioner accordingly prayed for refund of the amount deposited by him. Stop. The prayer of the petition requested for refund by a communication dated 4th December 2022. The petitioner has filed a supplementary affidavit in court today, annexing the communication of the bank dated, what is the date?
August 8th to 24th.
8th August 2024, wherein the bank approved the refund request and agreed to pay the principal sum to the petitioner. Stop. The petitioner claims interest on account of the amount being withheld by the bank. Paragraph. Learned advocate representing the bank submits that there was no fault on the part of the bank in not refunding the money. Stop. The possession of the property could not be handed over to the petitioner because of the restraint order passed by the Learned Tribunal. Stop. Paragraph. It has been submitted that direction ought not to be passed for grant of interest. Paragraph. It appears that, admittedly, the bank is holding the money of the petitioner is holding part payment from the petitioner from August 2022 and complete payment in complete consideration amount from November 2022. Stop. The request was made by the petitioner for refund of the money in December 2022, which the bank acceded to only in August 2024. Stop. Had the money remained with the petitioner, he would have invested the same in any other account or could have utilized the money for any other purpose. Stop. The bank, being the custodian of the money for so many months, ought to refund the principal amount to the petitioner along with interest. Stop. The petitioner ought not to be penalized for participating in an auction process initiated by the bank, and despite being declared the highest bidder and depositing the sale consideration amount, will not be refunded the amount along with interest, as the subject property could not be handed over to the petitioner. Stop. Paragraph. In view of the above, the instant writ petition is disposed of by directing the bank to refund the principal amount to the petitioner along with statutory interest at the earliest, but positively within a fortnight from the date of communication of this order. In the event the payment is not made within the stipulated time frame, comma, then additional interest of 2% shall be paid to the petitioner on and from the date on and from the due date till the date of actual payment. Stuff, paragraph. আমি কি বললাম dispose of?
হ্যাঁ, dispose of.
Or dispose of টা কাটুন তো। হ্যাঁ, the bank is directed, ঠিক আছে? The matter is made returnable on 10th of March 2025 for recording compliance.
May I request only one thing? Only one request. The statutory word may be deleted and the simple interest. There is no word like the statutory interest in banking terms. So simple interest, that will be sufficient.
What is the rate now?
What about banking rate? The RBI guidelines are there.
Yes.
That statutory, instead of statutory, there has to be
আচ্ছা,
simple.
simple interest করে দেবেন।
I'm grateful. Grateful. Only one more request. The petitioner is hereby directed to cooperate with the bank if any documents is required, suppose PAN card or.
I was always cooperating, my lord. I have disclosed
one
all
line
those
maybe.
documents, my lord. I was
Needless,
always cooperating.
needless to mention that the petitioner shall cooperate with the bank
I'm grateful.
for obtaining the refund of the amount as mentioned herein above.
Grateful. I'm grateful. Deeply obliged.
My lord, I have instructions to withdraw this writ petition challenging the notice issued by LIC finance agent under the SARFAESI Act. I am proceeding before liberty to proceed before the DRT.
Right. Learned advocate representing the petitioner submits upon
My lord,
instruction.
if there is a remedy, my lord, under the statute, my lord, liberty is, my lord, redundant, my lord.
No, in the writ petition,
আচ্ছা কি বললাম?
My lord,
His client has
my lord,
his
indicate one
client has expressed his intention not to proceed with the writ petition any further. Stop. The petitioner intends to avail the remedy available under the Securitization Act, SARFAESI Act. ঠিক আছে? In view of the aforesaid submission, the writ petition stands dismissed as withdrawn. Stop. It will be open for the parties to take necessary steps in the matter in accordance with law. Who are you representing, sir? Who are you representing?
I'm, my lord, the LIC housing file, respondent number 2.
Give your appearance.
I am for the private respondent.
Please enter your
grateful,
appearance.
man. Grateful.
My lord, I am for the petitioner, my lord, I am
favor the
for not to my lord.
No. Now I will dismiss.
My lord, my
Because
signature
yesterday,
for my lord,
it stood dismissed on mentioning it has been restored.
my lord, my
for-
senior is not come today in the court, my lord. He is suffering from fever, my lord.
Where is Mr. Hussain? He was there on the last occasion.
My lord, he is suffering from fever, my lord. He is not come today in the court.
He is suffering from fever. Where is the advocate on record? What is your name?
My lord, my name is Orpita Dhar.
Where is K.R. Sutradhar?
She is not come.
Here, nobody will come, and how will the matters proceed in court? আচ্ছা লিখুন তো। An accommodation has been prayed for on behalf of the learned advocate representing the petitioners. Paragraph. It appears that the petitioner is not diligent enough to proceed with the matter. As last chance, the matter stands adjourned for this week.
I'm grateful.
Yes, record your appearance.
My lord, I am appealing for this state, my lord. My lord, my instruction and not reported.
You already filed an instruction on the last date, possibly?
And report also.
Summary type.
My lord, admitted fact petitioner already My lord, kindly see page 4 and 5, my lord. Kindly see. Petitioner already, my lord, 6-3. This is to inform your kind
It is a midterm
confirmation.
revision of rent,
Rent.
right? How could you do it in the midterm?
3 years complete, my lord, increase the rent of the
No, but
petition.
you have reduced it instead of increasing.
Yes, my lord.
You have reduced it.
Due to mistake, my lord.
Mistake?
My lord, kindly survey the report. Petitioner was present. Survey the report, my lord. Kindly see.
Hand over a copy.
Page
Hand over
9.
a copy to your learned friend.
Yes, yes.
Kindly take the earlier report. The first report.
Oh, it's the same thing. It is reduced.
Already admitted.
6309. It's reduced.
Kindly take the first report.
Yes.
Kindly come to my lord, page 28. This is the assessment, and kindly take the next page. This is the sketch map.
Sketch map. Petitioner was
And
present.
This was the assessment made of 19,449.80.
Mistake, due to mistake.
What he's
Mistake?
telling.
Yes, my lord.
How it is? But I had
How do you see that it is a mistake?
1231 square feet.
Yes, 1231 square feet.
After
1231
after
square
30
feet, that has
years.
been calculated.
After 30 years.
Kindly bear me, Malad, for a moment. Kindly take first the. This was the revision order, Malad, page 31. Page 31 of the writ petition.
Now tell me one thing. If these factual disputes are brought into this, can the writ court enter into?
I'll show
It's
my
a
lord. Kindly.
absolutely landlord-tenant dispute.
No, my lord, that I'll be showing, my lord. This is the guideline, as per the guidelines, as per their own circular. This revision was made as per their own circular. Kindly take this 31 is the revision. Kindly note the date, 10th December 2020. Now, he is the competent authority, special land acquisition officer. That was the assessment I had just shown, page 28. Now, 9/3/2023, this was reduced. 6309. Now, kindly take what they are showing. Kindly take page, the first circular which they are relying on.
1994.
Page 27 of the report.
Total circular is existing at present exists.
Page 27 of the report. Kindly take page 27.
23rd November 1994.
First, you satisfy the court that your writ petition will be maintainable.
I'm coming, my lord. I'll be showing it, my lord. Kindly take, my lord, 27, page 27 of the
Yes.
report.
27 I have seen.
This is report, the second paragraph. After careful examination, it has now been decided that the revision of rent for hired accommodations which were originally hired 30 years back or earlier, rent should be assessed in terms of the circular quoted above. That was of 1993 circular. The revised rent in such a be freshly assessed rent subject to the conditions that the assessed rent should under no circumstance be more than 150%. Now, even if we proceed, the last rent, prevalent rent was 4,206. If it is 150%, it comes to 10,515. Now, how they could have done it to 6,300, I don't know. Because by that time, 30 years has left. Now, what they did, kindly take the next circular, page that I have annexed in the writ petition, 2013 circular, page 27 of the writ petition. 1994 circular was superseded by 2013 circular. That page 27. Page 27 of the writ petition.
Report, please.
একটু আমি বলে নিই। Page 27, kindly see last bottom paragraph 2. You'll find this circular. Considering the rapid hike of rate of rent in the market, the rent shall be enhanced up to 20% of the present rate after every 3 years. Has you also got it? Kindly take page 27 once.
At present.
Yes, page 27. I've seen.
Of the writ petition. Considering the rapid 5-year enhancement of rent shall be made automatically after expiry of every 3 years from the date of application from the house owner is not mandatory. The maximum permissible limit of increase of rent expiry of a period 3 years. The enhancement of rent may be made 3 times consecutively, and then rent shall be assessed afresh after 9 years if the same hiring department continues to occupy the said premises. Here 1991, the same CDO, Child Development Officer, is occupying the premises. Since 1991, for first time, he has proposed for fresh assessment under this circular. This 2013 circular. It supersedes both 93 and 94 circular. Now, it both supersedes. Now, this revision was made by the competent authority as per this 2013 circular, paragraph 2. Now, this was sought to be revised. Now, kindly take the report once again, page 37 of the report. Page 37. Kindly take once again, page 37 of the report. This is 16 June 2022 circular. Has you also got it? These now supersede 2094, 2013, now 2022. Now kindly take paragraph 6 there of page 39. Paragraph 6 of that circular, page 39. Cases where fixation or revision of rent in respect of the premises already settled and accepted by the in a manner mentioned should not be reopened or redetermined of such rent in respect of the said premises during the period of validity of such fixations. Now, in my case, the revision was made on 10th December 2020. Now, the second revision, unilateral revision without hearing, that took place in 2023. Kindly take page 30, the impugned, page 31.
Same page, para 7, kindly see.
Page.
Same page, para 7. 5 years. Next.
Page.
Rate chart of the locality must be updated.
Page 31, kindly take, it is
every 5 years.
10 December it was. Now, this was sought to be revised on 9th March 2023. Page 32. Reduced on 9th March 2023. I am not asking anything. I am asking as per their own circular. Now, they had no power to reduce it.
Tell me, why will it not be treated as a landlord-tenant dispute?
This is where the state is the tenant. I can rely upon the judgments, First 2005-12 SCC 148. There, the same thing happened. The court said that it is, since it is 226 and the state is the tenant.
Let me see.
The fixation can stand. That answer আমার কাছে নেই। এটা আলাদা।
আমার একটা কপি দিন।
Reported judgment 2005-12 SCC. Page 148.
2005. SCC. SCC page কত?
148.
148 page.
There is no disputed questions of fact. I am asking as per their own circular, which is binding on them. But if they do not follow, it will be violation of Article 14 also. Because in one case, they will be following. In my case, they will not be following. This is not permissible. Now, so far as these contractual disputes, my lord, even if we treat this is a, there is an purported lease agreement also of 1991.
Legal.
1 minute, yes.
Even then, the Supreme Court is now deliberated the matter. It is not so strict that in a contractual matter, court will not interfere where the state is the other party. I am relying on the latest judgment of the Supreme Court, 2024 SCC online SC 1682. So 3 judges bench judgment, my lord. Justice Ashok Ganguly order কোথায় গেল? I'll kindly take first, my lord. I'm just making the paragraph, citing, pointing out the paragraphs. Paragraphs are 41, 44, 54, 55, 56.
1 minute, 1 minute. 41, 44.
For 54.
41, 44.
44.
54.
54. 55.
Yes.
56 and 58.
All right.
Now may I start with 41, my lord. This simplistic approach of the courts in deeming every act and actions of the state which was complained of as nothing more than a contractual dispute or a case of breach of contract often led to the state abusing its position and acting unfairly under the misconceived notion that all its actions such as award of contracts or tenders were nothing but a largesse, a generosity bestowed upon its citizens, which it can at its own whims choose to deny, alter, modify, or take away without any consequences. These often led to conflations of power with duty and resulted in every arbitrary exercise of the power by the state under the guise of contractual dispute to remain unchecked and undisputably before the courts and out of reach of judicial review, undermining the rights of the citizens to have their interests safeguarded and protected. My lord, this reference was made, I am skipping. Now kindly take, my lord, 44. Next page. The interplay between the judicial review and administrative discussions has been dynamic process as new challenges and complexity kept on arising before the courts as regards the state's action and governance. It continued to refine its approach. This ongoing dialogue between the courts and the executive branch contributed to the development of a more accountable and transparent administrative framework, paving the way for the exercise of judicial review even in the realm of contractual disputes, to achieve a fine balance between the efficiency and fairness in the policy decisions on one hand and the rights of the individuals and overall public interest on the other. Then, my lord, kindly take, my lord, paragraph 54. The law on the subject which we are dealing was laid down exhaustively by this court in its decisions. Joshi Technologies, my lord, the position, this has been quoted. Then 55, kindly take, my lord, the next page, Roman 3, exercise of writ jurisdictions after the contracts comes into existence. As you lastly got it. This court held that even after the contract comes into existence, there are two things. One is prior to contract being executed and after the contract being. This court held that even after contract comes into existence, and actions may lie by way of writ to either obviate an arbitrary or unreasonable actions on the part of the state, or to call upon it to honor its obligations, unless there is a serious or genuine dispute as regards the liability of the state from honoring such obligations. existence of an alternative remedy or a disputed question of fact may be a ground to not entertain the parties in a writ, as long as it is not being used as smokescreen to defeat genuine claims of the public law remedy. Then, my lord, 56. What can be discerned from the above is that there has been a considerable shift in the scope of judicial review. I just pointing out what the court now thinks. Considerable shift in the scope of judicial review of the court when it comes to contractual disputes where one of the parties is the state or its instrumentalities. In view of the law laid down by the court in ABL, it is well known, Joshi Technologies and MP Power, it is difficult to accept the contention of the respondent that writ petitions filed by the appellant before the High Court was not maintainable and the relief prayed for was rightly declined by the High Court in exercise of its region, where state action is challenged on the ground of being arbitrary, unfair, unreasonable. The state would be under an obligation to comply with the basic requirements of Article 14 of the Constitution and not act in an arbitrary, unfair, and unreasonable manner. This is constitutional limit of their authority. There is a jural postulate of good faith in business relations and undertaking, which is given effect to by the preventing arbitrary exercise of powers by the public functionaries in a contractual matters with private individual. With the rise of the social service state, more and more public-private partnerships continue to emerge, which makes it all the more imperative for the courts to protect the sanctity of such relations. Then 58. Thus, the demarcations between a private law element and the public law element in the context of contractual dispute, if any, may be assessed by ascertaining whether the dispute or the controversy pertains to consensual aspect of the contract or tender in question or not. Judicial review is permissible to prevent arbitrariness of the public authorities and to ensure that they do not exceed or abuse their powers in contractual transactions, and requires overseeing the administrative power of the public authorities to award or cancel contracts or its stipulations. Now, here in the present case, now relying upon these principles, in the present case, the premises was taken on rent pursuant to a purported lease agreement in 1991. It was to be reviewed first in as per the 1993 circular, then 1994 circular came, then 2013 circular came. They did not revise it. In 2020, they revised it, treating it as a fresh tenancy. Now in 2023, after the circular of 2022, which prohibits any alterations of the rate already fixed, they suddenly reduced it. No hearing, no reasons. Even if you see the 1932, page 32, it doesn't show any reasons. It is substituted by their report that this is the reasons. But 32, page 32, once again, you will also kindly come. Page 32, it doesn't give any reason.
Where have you mentioned that it was a mistake?
Yes, my lord.
Where have you mentioned? Have you mentioned anywhere that it was a mistake?
Kindly take page 32 once. Right? It doesn't provide any reason whatsoever. Page 32 of the writ petition. Now, there may be situations where they follow it in respect of one individual and just withdraw it in respect of mine. This is arbitrary exercise. How could they do it without hearing me? When this has been, assessment was made, a map has been prepared, calculations has been done. They are saying that 1994, it cannot go 150% above. Even the 150% has not been followed.
In respect of rent, my lord, a district magistrate, any district magistrate jurisdiction up to 8,000. And land department, a head of the land department up to 10,000. A secretary of the concerned department above 10,000. My lord, a DM and head of the department no capacity to pay the rent, 19,000.
Did you receive 19,000 ever?
No.
19,000 you never received?
Never paid.
They straightway revised it. 2 years they did not pay any rent. From 2020, no rent was paid.
Page 6, my lord, of the report.
How could they do it? My lord, even if we accept for the time being that it should be 150%, that is also not coming. It comes to around rupees 10,500. And kindly just see once, my lord, page 32. It doesn't say mistake. It doesn't say why they are cancelling it. Page 32 is totally silent.
From 2022, no payment has been made.
Payment only after this assessment they remitted in my bank account.
For the period?
That I need to take instructions.
9,000.
Because this was
and the rate?
find it
306.
has been done with effect from 1st of August 2022. 20.
And the rate?
Rate is 6,000.
9,000.
What basis?
9,000.
Any of the circular they did not follow. No circular. I could have understood that they said no, it is 94 circular will be applicable.
Did you mention anywhere that it was a mistake?
Yes, my lord.
Did you mention anywhere that it was a mistake? Nowhere, even in your report that has been filed by the deputy director. Nothing is mentioned with regard to the mistake.
Acquisition officer. Special land acquisition officer.
Where is the mistake mentioned?
It is better, my lord, let the matter be remanded back to the competent authority for, my lord, fixation afresh after giving an opportunity of hearing. If your lordship show things, because my lord, according to me, my lord, 19,000 they could not have reduced. It is to be treated as afresh.
There is nothing mentioned. Ashunta. Submission made on behalf of both the parties. A report forwarded by the Special Land Acquisition Officer, North 24 Parganas, Barashat. Signed on 11th of February 2025. Hand over a copy to him.
Yes, yes.
Already.
Acha. Be taken on record. Stop. Let the matter appear in the list marked for orders on 26th of February. দাঁড়াও একটু দাঁড়াও call 18
I'm for this one.
I'm for the state.
Under instruction from my client, Lordship, I want to withdraw this matter, Lordship.
You want to withdraw? Why?
So that I don't know, but my client over.
Feel could stay your lordship order.
Which order?
Your lordship
By
order.
your
that
lordship
we
order,
asked to release the vehicle.
You have released it?
No, my lord.
They prefer an appeal and there is a stay, Lordship. Under
Oh, there is a stay? You want to withdraw?
Lordship,
Where is? Please come. Learned advocate representing the petitioner produces a copy of the instruction allegedly signed by the petitioner on 12th February 2025 requesting withdrawal of the instant writ petition. Now, Malikun expressing his desire not to proceed with the instant writ petition. Stop next. In view of the above, there is no requirement of proceeding with the writ petition any further. The same stands dismissed as not pressed. Instruction forwarded by the petitioner to the learned advocate be retained with the records. Call 19.
Good.
Well, at item 19, my lord, I appear for the petitioner. This is the matter, lordship, where
private respondent, my lord.
a shop and a manufacturing activity was being carried on without obtaining any license. Lordship had passed an order directing the fire authorities to file a report. But however, there was one issue, Lordship, perhaps some miscommunication on our part. We apologize. In the order, Lordship.
Is the Pollution Control Board? Where is the report? Has it been circulated?
No.
Is the report there? You do not know anything.
My lord, the
All right, I'll
fire
pass it over
My
for the
lord,
time being.
My lord, may I shortly indicate one issue, my lord? Actually, the problem has been created, my lord, due to the reason, well, if your lordship kindly takes up, well, page 8, para 12 of the writ petition itself.
Yes.
Well, an inspection after the getting the complaint, an inspection was made on 9th September 2024 in the shop room.
Yes.
Where existing fire safety certificate could not have been produced.
Hmm.
Thereafter, so far my instructions are concerned, well, I only received it just now. That after that, as a follow-up, if your lordship kindly see page 87.
Yes.
Well, there, of that inspection, it has been stated, in connection with the above subject and reference, it is observed that regarding you, that after receiving a notice under section 35, dated 24/9/2024 from this department, where instructions was given to comply with the fire safety certificate from this department, but you did nothing till now. Well, that's why this has been given to stop. But subsequently, so far my instruction goes that on 9th of October, they obtained this license of this fire.
So fire license was obtained prior
So
to
for my
passing.
instruction, I need to get the written instruction. Otherwise, my lord, I don't have right now.
All right.
So I handed over the copy of the certificate of the fire
That
Fire
I did not get a-
from the head office.
My lord, it was not within our knowledge that this has been obtained. So after it was produced by my learned friend, lordship, we made inquiries. Now what we have found out, and my learned friend will confirm, when this inspection was made, after that the private respondent was given a hearing. Apparently the fire certificate was shown to the fire authorities. This step has been taken pursuant to that for cancellation of the fire certificate because
A report from your
Lordship,
department will be required.
lordship, because may I just point out only one fact, lordship, because
Let it come from the fire department.
Great, lordship.
And my lord will also
But in any case, lordship, under law, my submission is the fire certificate, the trade license, none of these or the GST registration cannot be obtained because the mandatory precondition of the law is you need my consent. The consent of the landlord has to be obtained in writing, and thereafter a valid and subsisting rent agreement and a lease agreement has to be produced. Without these two documents being given, no such license can be issued. Now, we inquired as to how they got this license. The answer is now from last year, lordship, what has happened is in the portal, you can
Online
any
you can
person
get.
can log in by giving an undertaking. You can take out the license immediately. That is subject to cancellation if any contravention is discovered. And
Adverse
that is what
report
we are
is
doing.
fine.
They inquired, they came into the shop room. After
Very well.
being satisfied, it has been
Mr.
issued.
Mukherjee, is there any pollution under control certificate or anything of that sort?
Let me file a report. Already there is a
Direction.
Having this time, my lord, I shall file the
Ajay, ठीक है, please come. On the prayer of the learned advocate representing the Fire and Emergency Services Department and the Pollution Control Board. The matter stands adjourned till next Wednesday will be all right? 19th. Stop. A report from the Fire and Emergency Services Department and the Pollution Control Board shall be prepared and circulated prior to the adjourned date.
And lordship may also direct the municipal authorities also regarding the
Which
trade license.
municipality?
My lord, the urban development department, it's under the Bidhannagar Municipal Corporation. They are also parties. They were there on the last occasion.
Now also they are there.
There. So if
Yes.
my lord kindly directs them to give a report as to the trade license as well, because
But
my
then the trade license, you say it was done on the portal online and it has come.
lordship,
But
after
did
the
you
UD department-
intimate?
the UD department?
Did you intimate the authority that these are the adverse
Lordship,
findings?
after that hearing has been, after Lordship passed the order, hearing was given to us. That is why I'm submitting.
That is only by the Fire and Emergency Services.
Lordship, also the UD authorities after,
UD
because that was
UD department also you take instruction.
Since 1978, I am doing business.
All right,
that is
all
being
right.
renewed from time to
Let-
time. It's a Floyd
let
to
a
evict me,
report. Let
I
a
will
report
consider it.
as to whether any license was granted by the UD department shall also be informed on the next occasion. Whether
My
any
lord,
license was
may
granted.
I prefer an indulgence, my lord, a little more time, my lord, at least 3 days, my lord. Because otherwise I'll have to inform them because I didn't have contacted them.
All right, 25th of February, I'm fixing it.
Grateful, Lordship. Lordship may retain its position in the list.
It'll be there in the same
Grateful,
position.
Grateful.
I'm grateful.
Grateful.
25th.
May please Lordship, I am for the petition.
I appear for the bank.
Lord.
Today in the morning only I have received the instruction. But basic information I can provide.
My Lord, can you see paragraph 5? I have a huge amount in the bank, in the branch.
You are for the bank?
Yes.
Bank. And Bank of Baroda in James Long Saroni. I have savings in saving of 4,81,000, huge amount as FD in the state bank. All of a sudden, they have blocked the account and freeze the account. As a result, I could not access in the state bank.
Is it because of any fraudulent transaction?
Yes. There is a cybercrime police station of Vadodara, Gujarat has initiated a complaint, and it is through the cyber portal that this account has been frozen. We have no role to play with regard to marking of lien or freezing of the account.
Nothing.
But I can provide the details of the cybercrime police station to my learned senior friend. If my learned senior friend wishes to add them as a party or directly approach them, my learned senior
Well,
friend.
in the meantime, what I am paying, the amount which fraudulent amount, keeping that amount in my
No, he doesn't know.
Well,
He
they
doesn't
have
know.
Have a chart
Yes.
which indicates the amounts, but we are not the authority to either freeze or defreeze. But it is absolutely about the
Let me see. You have a written
I
instruction.
do not have a printout
All right.
of this. I can share it with my learned senior friend.
But then I need to see also.
Yes, my lord.
That amount, other amount can
my lord,
be
one
freezed.
entry is there with regard to Mahushumi Kinan Mahapatra. It is marked as 1 lakh. 1 lakh. This is arising out of a stock scam relating to some share
Stock
trading.
trading,
Share
yes.
trading. So that amount is mentioned in the chart. There are several entries with regard to Bank of Baroda, but the name of Moushumi Mohapatra do not appear in my chart.
No, but then at the same time, you say that it is you have not frozen it.
We have not. We have not.
It is the cybercrime.
Cybercrime. If
From Vadodara.
From
You
Vadodara.
give the details, they can contact
Yes.
them.
Well, I can provide the mail ID even with the cybercrime and the details of the police station. If my learned senior friend wishes to add them as a party or directly approach them, whatever.
No, as my experience goes, nobody from the crime department from other states appear. So adding them, I do not know what purpose it will be served. You just share the information with the petitioner so that, and a copy to the court.
Yes.
Let
Well,
us see what can be
within
done.
half an hour, I'll get a printout and.
In that case, I'm passing it over. You
Well,
get it,
well,
and we can pass orders today itself.
I'm করে দিচ্ছি।
All right.
Divya.
Call the compilist.
We beg to appear for the petitioner, Lordship.
Yes. What is the matter about?
The Lordship, the matter is about the petitioner had taken a home loan, Lordship. He had taken the home loan in 2010. The amount was 9,15,000. Now he foreclosed the amount and he went to another bank, Lordship. The money was given by another bank and he transferred the loan to another bank. The grievance of the petitioner is that he took 9.15 lakhs in 2010 and 2018, Lordship, he gave 9.24. But he was never a defaulter. What is apprehending, he has given more money than the contractual amount. So, Lordship, what the prayer of the petitioner is that, my Lord, there's an amortization schedule. That is the schedule in which you get the interest and the rates and how it is to be paid. In 20 years was the amount, money time frame, the term. He has squared out the entire amount to 2018 and left. He went to other bank, entire amount. This bank, UCO Bank, has got the entire money. So there is no question regarding that. They have given it in 2020.
But there
no
must be
objection.
some foreclosure charges.
There are foreclosure charges. That is absolutely right. But we have not been informed as to what the amount is.
Who is
Because
the bank? Are you there?
I am appeal for the bank, my lord. My lord, in every loan, my lord, the interest portion is charged higher at the initial period. Then it comes through a reducing balance, and at the end, the principal, my lord, knows in car loan, housing loan, my lord, even in the agreement of the loan agreement,
The same has been mentioned.
It says that it will be, interest will be charged first.
Right.
Sometimes it's floating amount, Lord.
Whatever.
On the third page of that agreement, my lord, this is not paginated. I've got just now from bank. Clause 2.2D.
If we don't have these copies, the bank never gave us these copies.
The agreement you have signed also.
No, you have signed, but actually what the bank does, they do not share copies, Lordship. That is the difficulty.
It is clause 2D. Any money due and payable to the bank and received by the bank shall be applied in such order as the bank in its absolute discretion may from time to time conclusively determine, save and except whatever. Then, my lord, comes without prejudice to the above, the monies received shall be appropriated in the following manner. Firstly, towards liquidated damages and further interest, including uncharged interest. Okay. Then number 2, my lord, secondly, towards the interest charge. So first it will be charged against the interest. Then number 4, lastly, towards the principal amount due. So that is how, and that is a system generated. My lord, my learned friend has also annexed the annexed the accounts, where it shows, my lord, from page at page 16, annexure P2, entire amount, whatever the loan account, it is reflecting that how much interest has been charged, how much debit has been made, how much credit has been made, how much amount. I am not on that he has not paid the loan. The loan is fully paid. But, my lord, as per bank's norms or as per the RBI guidelines, my lord, the interest has been charged, and that there it shows that still 9 lakhs was due. That is because, my lord, all banks do it, my lord, all the nationalist banks also. This is also a nationalist bank. That they are charging at page 28. It shows that 9,51,000 at page 28, my lord. 9,51,000 issue. At 9,51,468 was due or as on 2nd February 2017, and that is the amount my learned friends client has paid. That amount, and the loan was liquidated. No objection certificate was given.
So what remains if the loan?
What remains is, Lordship, 9.15 is the amount I taken. I repaid 9.24 and I did not make any default. So in total, I have paid 19.55 for 8 years only.
So
that 20 years I did not complete. I have paid repaid.
Doing.
So I need the amortization schedule, Lordship. How they have charged me? That they have never given.
You have given this. They have given to you today.
Yes, today they have given, but I did not have a copy of this. There.
Now, please come.
Lordship, kindly give me opportunity to go through this. I show my client.
What will the court do after you go through this? The court doesn't have anything to do.
But, Lordship, I want the amortization schedule, Lordship. They have charged me more. The amount cannot be more than the principal amount, Lordship. 9.15 lakhs was the loan amount, and I have repaid back 9.24. In 8 years, I paid the rest of the 10 lakhs. So 10 lakhs I paid in 8 years. That is 19.55 I paid in all.
Petitioner is aggrieved by the amount charged by the bank. In charged by the bank, despite he clearing off the entire loan amount prior to the scheduled date. Paragraph. The petitioner. Now, the loan agreement of the bank signed by the petitioner has been handed over to the learned advocate representing the petitioner in court today. That's a loan agreement date 23rd September 2010. According to the learned advocate representing the bank, the calculation has been made as per the RBI guidelines and the conditions mentioned in the loan agreement. Paragraph. In the event the petitioner has any further queries, it will be open for the petitioner to approach the bank by filing written representation. Petition disposed.
Lordship will kindly appreciate in 9.5 lakhs, I have paid 10 lakhs, Lordship. The more than the loan amount, Lordship, entirely paid. Then also 9 lakhs is due. Grateful, my lord.
May I please your lordship? Lord, the only Before that, I am saying, Lord, on Monday.
This is a matter of 2022. Did you give notice to the other side?
Monday, unfortunately, from the corridor, the file has been misplaced. Somehow, I have recovered on last evening.
Yes.
That's why no connection can be done.
No notice can be given.
This is the position. Could not be.
All right, please come.
One thing I am
And appears
submitting,
for
Lord.
the respondents. Yes.
One thing, Lord, I am submitting, Lord. Only the hearing has been done one time. No further hearing is done. Page number 53. That is the,
Let the other side come.
that can be.
Acha. Let a notice be served upon the learned advocate representing. Mr. Chatterjee is here.
57 this is.
56.
56 আমি ছিলাম
56
I see your name recorded. Only consideration of something he praised.
Yes.
For which one? Which?
That is page number. That is similar. Page number 53. The hearing was considering my representation. That hearing lastly held on 8th, third line, 8th December 2021. But thereafter no date is given. That is the only prayer. That hearing can be concluded.
Hearing has not been concluded?
No.
Sure.
Sure.
There are so many documents annexed thereafter.
But thereafter all the reminders and likewise all are reminders to the joint registrar, that is response number 3. All are to the response number 3.
Acha.
By the secretary of the. That is also the prayer A. That is also.
Learned advocate for the petitioner.
kindly observe, if not, will it only be concluded?
Yes, keep not.
Acha. Submits that. The representation of the petitioner was considered by the authority on 8th. Authority will respond number 3 on 8th December 2021 regarding renewal of the society. Stop. After the hearing conducted on 8th December 2021, the matter has not been conclusively decided or finally disposed of. Stop. Prayer has been made to direct the respondent number 3, being the
joint registrar.
Joint registrar cum development and planning officer, firm, societies and non-trading corporation. To dispose of the representation of the petitioner. Representation na kore prayer of the petitioner. Stop. Paragraph. There is nothing on record to suggest that the prayer of the petitioner stood finally disposed of. Stop. In view of the above, the instant writ petition is disposed of by directing the respondent number 3 to decide and dispose of the prayer of the petitioner regarding renewal of the society. If not done in the meantime,
Yes,
in accordance with law, at the earliest, after giving reasonable opportunity of hearing to all the necessary parties.
We are grateful.
Within a period of 12 weeks from the date of communication of this order. Learned advocate for the petitioner is directed to forward all relevant documents in support of.
I shall, along with communication, I shall serve again the copy of the writ petition.
Yeah.
That will serve the purpose. All documents are here.
His prayer to the aforesaid respondent at the time of communicating the order of the court.
We are grateful, my lord.
Yes, next.
Should I appear for the state respondent?
This is an upgraded matter. Were you given notice of upgradation?
No, my lord.
No. And so the matter has been mentioned for upgradation seeking, citing urgency. Stop. At the time of call, none represents the petitioners. Petitioners. The writ petition accordingly stands dismissed for default. The state is represented by the learned counsel.
We are grateful, my lord.
Matter Mr. Soumitra Bandyopadhyay and Priyabrata Bottabel. They were also present Monday and also yesterday. And that's why over telephone also today I have talked with them. They will remain present. Soumitra Bandyopadhyay and Priyabrata Bottabel. I tried to issue notable notice. We are here. We brief.
Are you filing an exception to the report that has been filed?
No, nothing is there. Practical fact is that, my lord, the without taking any following the procedural law.
But then the order mentions that it has.
All of them complete. Only point is all the lands are filled up. Several acres of land. They have excavated the land willfully by 16 dredgers. But by virtue of the order, all our soil has been filled up from taking from elsewhere. Only with regard to 2 years compensation for 6 crops, that is not done.
Is any representation there for seeking compensation?
Yes. Only that part is there.
Where is that?
Well, I kindly see first order. Kindly see first order. I am going there. Kindly see first order.
Yes. Show me the annexure.
Yes. I am showing you. My lord, that is page number 65. And also page number 65, and also prayer is there. Prayer is also there, madam.
This representation has not been considered?
Representation, in view of the representation, 58. In view of the representation, and by virtue of the order, the district magistrate, in his presence, the excavated land has been filled up.
Yes, but compensation?
Only in respect of paying the compensation, that has not been rectified.
You did not seek for compensation in your representation?
And
by paying
and
suitable
that is
and
also
proper
in the prayer,
compensation.
kindly see prayer A and B at page number 16.
Yes.
Prayer B.
আসুন তো দেখি। The petitioner seeks compensation. For which, what is the period?
Kind looks for a moment, dated 21st December 2023. Everything is there. 21st December 2023. We transfer from the report that the apprehension of the petitioners are justified. In addition, the land of the petitioners, apart from petitioners number 8 and 10, have been admittedly excavated by the respondent authority insofar as the petitioner 10 such. Thus, paragraph 3, prima facie storing strong case has been made out by the petitioners that the respondent have undertaken a high-handed action and the work of excavation of petitioner's land without according the same, without prior notice to the petitioners, except petitioner.
So this point has been kept open. Paragraph 5, petitioners are entitled, whether you will be entitled to compensation is kept open.
Open, that is not been decided.
Yes.
That should be decided by the district magistrate. Only that part is left. But several acres of land that has been filled up.
কি বললাম? Compensation on account of illegal excavation of his private land. Stop. By virtue of the order passed by the court, comma, the excavated portion of the petitioner's land has been filled up. Stop. The petitioner seeks compensation. Stop paragraph. The petitioner is granted leave to make a comprehensive representation before the district magistrate. Stop. Now, district magistrate highlighting his grievances. Stop. In the event such a representation is made, giving details, comma, then the same shall be considered by the district magistrate in accordance with the prevailing law. After giving reasonable opportunity of hearing to all the necessary parties and be disposed of at the earliest, but positively within a period of 12 weeks from the date of filing the representation.
Much original, grateful.
Well, in this matter, I am for the petitioner, my lord. I have served. My lord, in this matter is peculiar matter, my lord. All the lands of the petitioner were vested. The petitioner challenged the same in the civil suit. Permanent injunction was granted. The state preferred appeal, that was dismissed. Thereafter, the petitioner preferred writ petition before this court. This court directed to correct the record of rights. In the year 1998, that was not done. On the plea that civil court has no power. BLRO, my lord, declared that civil court has no power. My lord, civil court has no power or not, that will be decided by the higher court, my lord. Thereafter, my lord.
What are you praying?
My lord, for selling the property, my lord. Only, my lord, your lordship knows it very well that the record of rights does not create any title. Only there is a vesting, there is a mention in the record of rights that vesting. That is why nobody is purchasing. In the meantime, my lord.
Want correction of record of rights.
That have already been, my lord, prayed. I am only praying, my lord. Last page, kindly see last annexure, my lord. Representation before the Inspector General of Registration, my lord, for granting permission to sell. Because, my lord, all the courts declared the rights of the petitioner, my lord.
Granting permission to sell, is it a tribal land?
Vesting, they are saying, but vesting has cancelled. Competent authority has already declared. My lord, DLRO, District Land and Officer declared. Kindly see the order, page 43.
Then why are you here and why not before the tribunal?
Tribunal have I go in, my lord, tribunal.
Yes.
They directed. The file is not, my lord, BR case, my lord. File already missed.
And the writ petition that will be entertainable.
Yes, my lord, I am praying for consideration of the kindly see last page, my lord. 50 page.
There is an order under section 54.
My lord, highest court of the land, my lord, declared that the vesting order has already been cancelled. Correct the record of rights. BLRO is saying that file.
There is no correction of record of rights. Section 50 is there. You can go take steps. Why?
I have filed. They are not correcting because BR case record is not available. Only plea. For 40 years, my lord, they are saying.
State, what is your submission?
My lord, this petition, my lord, the representation made before the Inspector General permitting him to sell the property, my lord, subject to correction is not maintainable. But what I understand from the above that he has approached the tribunal. There is an order, my lord, directing the BLLRO to reconsider the case. Initially, this correction, his prayer for correction of record of rights has been rejected. He went to the appellate authority. The appellate authority directed reconsideration. My lord, what I understand, in case his case has not been considered, the appropriate remedy subject to correction lies before the Land Reforms and Tenancy Tribunal.
That is
For
only
correction of record of rights, he has to approach the court, or my lord, if the records are missing, there has to be reconstruction of the records.
How can writ court entertain this writ petition?
my lord, he is not in a position, my lord, for 40 years or 50 years, my lord. That is, he has already become ruined, my lord. All the
So, see, listen, all these stories will not help. You have to show some legal provision by which the writ court can entertain.
my lord, only my provision, my lord, the record of rights does not create any title.
Yes. So what?
That is why the vesting, recording of vesting in the record of rights has no legs to stand upon. That
Sorry,
is
sir.
why my land is.
The grievance of the petitioner is that he is unable to sell his land, as the record of rights wrongly mentions the same to be vested land. Stop. The petitioner has obtained order. The petitioner, the learned advocate for the petitioner, submits that the petitioner was able to obtain order from the competent forum declaring that the vesting
Appellate forum, my lord.
declaring that the vesting was illegal. Even thereafter, the record of rights has not been corrected. Stop. Because of non-correction of the record of rights, comma, the petitioner is unable to sell his land. Stop. Paragraph. The petitioner has made a representation before the Inspector General of Police and registration, police na, and prays for consideration of the same. Stop. Paragraph. From the submission made on behalf of the petitioner and on perusal of the materials on record, it appears that the petitioner is aggrieved by the recording of vesting in his record of rights. Stop. Paragraph. It will be open for the petitioner to approach the competent forum for correction of the record of rights in accordance with law. The writ petition stands disposed of. Services taken on record.
We are appealing for the state respondents.
Please come. The matter was upgraded on mentioning, citing urgency. Stop. At the time of call, none appears on behalf of the petitioner. Stop. Learned counsel for the respondents are present. The writ petition stands dismissed for default.
My lord, item number 20 pass over. My learned fit is here.
Please wait. I am in the midst of the list.
Well,
yes. 61.
I am for the petition.
Yes, please.
Lord, here the order of the it's private, my lord. Here, my lord, the order of the appellate authority under the Right to Information Act is under challenge, my lord. I had sought for certain information. Now, the facts which has led to the filing of the Right to Information application
No, tell me. You have sought for information and that has not been supplied.
That has not been supplied. First appeal preferred, rejected. Second appeal preferred.
Rejected on which ground?
Rejected, saying that this cannot be given to you.
All right.
Rejected, had to approach this honorable court for taking my lord direction upon the twice. This is the third round of litigation. Directing up the appellate authority to consider, and thereafter the appellate authority was not considering, again had to approach this honorable court for expeditious disposal. Thereafter this has been done. So, but
Now there is a rejection.
There is a rejection.
Show me.
That rejection is being impugned before your lordship. Rejection is at page 50. Before that, may I just once draw your lordship's can inform my lord?
What is the information? That
Yes, that is what that was. That was at page. The information that was initially sought for at page 18 kindly comes to that, and thereafter goes to my lord the rejection.
Page 18.
18. May I just place it? The entire thing is there. The undersigned states that it has come to his notice that
No,
a
don't go
vacancy.
to all those things. Tell me
Just one
the
paragraph.
queries. What are
Yes,
the
yes.
queries?
The background fact is that we had participated in a process for FPS mallet distributorship. Thereafter, I had sought for certain mallet things. Whether such and such had simultaneously applied for grant of more than one FPS license pursuant to the vacancy notification dated such and such. If yes, kindly supply the documents. Whether any near relative of such and such had also applied pursuant to the vacancy notification for appointment of FPS or any other location. If yes, please supply. Kindly supply the documents and records which have been supplied or deposited by such and such while applying for the grant of FPS license pursuant to the vacancy notification dated such and such. Whether simultaneous inspection stroke verification of the sites inquiry was simultaneously held in two places, in Pakuria and Khuni, on such and such respectively pursuant to the application made by such and such. If yes, kindly supply me the particulars of the supporting documents. Basically, the procedure is a report is prepared, and on the basis of that report, everything comes out. Your lordship is regularly taking tender matters where, my lord, in respect of the tenders which are, my lord, floated, everyone has to upload their documents so that the other person who has lost in the tenders can know whether this particular person who has been given the tender is having the credentials or not. Here also the same exercise was sought to be done, but here, since this is not an open portal, we had made for application under the Right to Information Act. Now, my lord, this application was first rejected. Next page.
Now come to the impugned order.
Page 20, thereafter impugned order. Kindly see the one-page rejection, thereafter the impugned order. Well, kindly comes to page 20 once.
Yes.
Mr. Such and such applied in both places, name such and such against vacancy. He was eligible for such and such, and his other application was dismissed. Vacancy notification was such and such. Nothing was provided. He cannot apply in two. At the time of submission of application, answeree was only an applicant, so it is irrelevant whether he's relative. But these things are not supposed to be said in. I'm made a specific query, specific answer, yes or no. Personal information cannot be disclosed as per provisions of RTI Act. Inquiry report cannot be disclosed to their party as per provision of RTI. So therefore, this is totally, my lord, non-speaking. I went up in appeal. Now kindly comes to the impugned order. My lord, page 50 onwards, this is all my lord, reiteration. Grounds of second appeal, copy paste. Deliberation and discussion, page 52. Appellant is present, advocate is present. Paragraph 10 is the answer. The commission observed that personal information is exempted under section 81J RTI Act. Besides, section 44(3) of the Digital Protection.
Same thing, the personal information they will not supply.
Yes. Now, my lord, kindly comes to the section 44(3) of the Digital Personal Data Protection Act 2003, which had sought to amend RTI Act. Next page is that act, my lord, I have annexed. Kindly comes directly to the last page, page 73. 3, last. In section 8 of the RTI Act, in subsection such and such, the following clause shall be substituted, namely information which relates to personal information. Now, lordship may kindly.
Where are you reading, please?
Page 73, last line.
73, yes.
Last line.
Huh?
This is the amendment which is being done, rather peculiar. One act is amending another act, but since both are central acts, my lord, legislative competence is there, we cannot, my lord, question
8
that.
of the Right to Information Act.
In section 8 of the RTI Act, in subsection L, for clause J, the following clause shall be substituted, namely, quote unquote, information which relates to personal information.
What was the initial one? This is a substituted
Yes,
one.
initial one is this. May I just place it and thereafter give all lordship is having mal.
No, you can read it.
Yes. This is section 8 is exemption from disclosure of information. J was information which relates to personal information, the disclosure of which has no relation to any public activity or interest, or which would cause unwarranted invasion of privacy of individual unless the central public information officer or the state public information officer or the appellate authority, as the case may be, is satisfied that larger public interest justifies the disclosure of such information. So previously was that personal information which relates to personal information, disclosure of which has no relation to any public activity or
The
interest.
later part has been taken off.
Yes.
It's only the related
And my lord,
covers everything.
now another thing has to be taken. What is coming within the purview of personal information has not been denied, not been defined. In RTI, information has been defined. In this act,
Personal Data Protection Act also there is no definition.
no. That is what I'm trying to substantiate. Kindly comes to the definition, page 54, 55. Only thing that I can find which may be to some extent relatable is page 656. Personal data breach means any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, such as destruction or loss of access to personal data that compromise the confidentiality, integrity, availability of personal data. So it is not defined. Now, what they have sought to do is this: by quoting the alleged clause of non-disclosure of personal information, they have tried to bypass the entire provision of the act, because transparency was the basis why this RTI Information Act was done, was taken into was enacted. I have competed in a open proceedings for appointment of for distribution of state largesse. FPS is a distribution of state largesse. Now, I will not be entitled to know what is the report.
Was this person last of all
Granted
the license?
Yes, I am filing another litigation
in two places.
No, in one places. My
One
contention in that proceedings would be that you could not have applied for two places, and my contention would be that you were not eligible because there was no inquiry held.
So you can proceed with that. What
Until I have this record, all my informations will be without any basis. This is point one of transparency. These things are, my lord, in respect of tenders in the open portal, my lord. All the tenderers, they have to upload their documents, so everyone can see. Lordship is every day taking these matters, my lord. All the documents which are coming are from the portal, which they have uploaded. Here there is no portal. Here they have to give under the Right to Information Act. So by quoting this personal information, my humble submission before your lordship is this: the entire pursuit of, well, I will not say that they are, my lord, in hands and all these things. I don't have materials to substantiate. But by doing this, they are doing something which is contrary to the act itself.
Very well, I have followed your submission.
Lord, I beg to appear on behalf of the respondent number 5, the information
Appellate
commission,
authority.
the second appellate authority. But first of all, we are not supposed to provide any information. We do not preserve any information of any authority or department.
You may not preserve, but then you can direct the
Supposed
authority.
to adjudicate whether there is when there is a complaint that we are not getting information, whether is information.
No, it is not this type of complaint. Here, the information sought for was disallowed.
Yes, Lordships, under a particular provisions of law. Lord, we have adjudicated, being a quasi-judicial authority, Lord, in terms of our own wisdom, we have said that yes, the reason provided by the authority for not giving information is correct. And that is our stand. First of all, there are 4 information shortfall. First 2 have been given. The third was
not
disclosure.
Not.
And the last was
Not.
What is the personal disclosure? This is in relation
Lord,
to.
if you Lordships kindly see page 53, Lord, 8, point number 8 in our order, Lordship.
In your order.
Impugned order.
Lord, first you Lordships kindly come to Lord page 18.
Yes, the queries.
Page 19.
The queries.
The point number 3, Lord, third queries.
Yes.
Kindly supply the documents and records which have been supplied or deposited by such Mohammed Qais Ansari while applying for the grant of FPS license. Lord, there are several documents. Now, Lord, in point
There
number
may
8
be
is
several documents, but certain documents were required to fulfill the eligibility criteria.
right, Lordships. Lord, point number 8, SPIO has said these documents are Lord, bank account number, Aadhaar card number, PAN number, property details, voter IDs. These were quoted before the Lord, second appellate authority. Now, what are the personal documents Lord, he sought for? That has not been clarified in his query. He said whatever documents he has submitted. SPIO said these are the documents he has submitted. So these can't be granted under Lord, section 81J, so far as the latest amendment is concerned. We opined that yes, their contention for not giving information or disallowing for providing information is correct. But that much we have done. Now, my lord, I leave it to your lordships. My lord, we have no personal interest being the quasi-judicial authority. If your lordships hold that yes, they are supposed to provide the information, your lordships can direct the authority directly for providing the information.
These are not only the documents which have been supplied. You have to supply your credentials for participating in a process.
What are the credentials? You want the Aadhaar and the PAN number and the property details of the
That is not. That is always there. I don't want those. I am not interested to know his
what is the exact
credentials. Is that
documents?
he has established this particular place, whether he is having the place to store the FPS materials. What is
that is not your query.
My
you could have
documents.
Could have placed your query in such a manner so that the answer could have been made.
They could have. There are many documents. I don't want Aadhaar and all these things. But
This
there
is
are
what
other
has been
documents. The
mentioned.
inquiry report is there.
Specific
Inquiry report is there. Inquiry report is there. They are saying no, the inquiry report cannot be given. Kindly sees. 3 is personal information. 1.
3 is personal information.
1 is not provided.
And 4 about
4 is also not provided.
Why? Inquiry
Saying
report.
that inquiry report cannot be disclosed. This is a basic
Why cannot
thing.
the inquiry report be disclosed?
Let it be. Let there be direction.
Inquiry report can be given, but then
Basic
certainly
thing.
the PAN, Aadhaar and the bank number.
I don't want.
You don't want.
Don't
also.
want. And my lord, as of today, disclosure of Aadhaar number is not required at all, because even
That is
if
different.
someone asks an Aadhaar card from me, I am only entitled to give only the last four numbers.
4 digits.
Kindly see what are the queries. Whether Mohammed Sach and Saj has simultaneously applied for grant of more than one. Answer should be yes or no. If he applies simultaneously for 2 places, then he is disqualified. He will not get anyone.
That is a different context.
See the answer.
Answer is yes.
Answer C.
Yes.
No. Had applied in both places. He was eligible for such and such, and other such was
He
this.
got your answer that he applied for both places.
Yes. Next.
Got the answer.
Next. Documents have to be supplied.
Which document? Why do not you pinpoint the document?
Application form which I have filled up. The inquiry report which might have been done.
Inquiry report I'll direct.
Thereafter,
forward.
whether any near relatives of Mohammed Ansari had applied pursuant to vacancy. 2. At the time of submission of application, Mohammed Sach and Sach was only an applicant. So it is irrelevant whether he is a relative.
How
If
will
near
the authority get to know who is the near
From
relative of the
what happens
person?
is, I cannot apply in 2 places. What happens there, my lord, in a particular block, I apply, my spouse applies, my brother applies, his spouse applies, my father applies.
But then,
So
it is only when it is shortlisted that the authorities get to know that he is the brother, he is the spouse, and he is the
yes.
father.
So therefore, that will be a clause which I can quote saying that, look, the entire thing is being rigged. in a proceedings where I can show.
As regards the inquiry report, I'll direct, but otherwise I am not satisfied with your
Let him produce the record.
queries.
Let him produce the record. The SPIO is also a party. The department is also a party. He is only
Supply. Why produce? He'll supply.
Let him
Please
supply.
come. The order of
the applications of my lord, both the places also has may be supplied. My lord, kindly may I just request your lordship to
Information
produce the
Commissioner.
records.
Dated 17th of January 2024 is impugned in the instant writ petition. Stop. The petitioner intends to obtain certain information with regard to a license of a fair price shop. Stop. Queries were made under the Right to Information Act, but the petitioner was not provided the information as sought for. Stop paragraph. The SPIO and the commission.
The first appellate authority also has denied.
Actually, the SPIO, the first appellate authority and the commission, being the second appellate authority, all have observed that the information sought for by the petitioner are personal information and exempted under section 8 within bracket 1 within bracket small j of the RTI Act. Stop. The provision of section 44 within bracket 3 of the Digital Personal Data Protection Act, 2023 has also been relied upon for not supplying the information as sought for. Stop paragraph. On a perusal of the queries made by the petitioner, it appears that the same has not been worded properly. Stop. The petitioner does not pinpoint the documents which he requires. Stop. It is only a bold statement for supplying documents and records supplied or deposited by another applicant for grant of FPS license in terms of the vacancy notification dated 12th February 2019. Stop paragraph. As regards the said query, leave is granted to the petitioner to make fresh application, giving proper details of the information that he seeks. Stop paragraph. The further query of the petitioner was for providing the inspection / verification of sites / inquiry report held in Pakuria and Ghurni on 25th of September 2020 and 28th of September 2020 respectively. The said inquiry report has not been provided. Where is it mentioned? The reason.
Page 20.
Page
20. Inquiry report cannot be disclosed.
Achha. Provided on the ground that the inquiry report cannot be disclosed to the party as per provision of RTI Act 2005. How has the State Commission dealt with?
Last page, same, everything. Paragraph 10.
Paragraph 10 is only personal information.
Yes, that
what
is
about
all.
the inquiry?
That is all. Previously, everything is
Discussed.
yes. Last
Okay.
line will be Miss such and such submits that applicant is asking for.
As the petitioner
10, 11, 12 is the
is also an aspirant for obtaining the license, comma, the inquiry report may be required to proceed with his case. Stop paragraph. The inquiry report ought to have been
reports. There are
Acha, reports of the two places ought to be supplied to the petitioner. Stop. The same is primarily for maintaining transparency in the entire selection process for grant of license of FPS. Paragraph next. In view of the above, the instant writ petition is disposed of by directing the, who is the SPIO?
Subdivisional controller. Response number 4, perhaps.
The subdivisional controller within bracket food and supplies. The respondent number 4
For the
here.
benefit of my learned friend, well, let the direction be given upon the response number 3. He is the first
district
appellate
controller.
authority. Yes.
আচ্ছা তাহলে 3 নম্বর কে করে দিন, the district controller to forward the
controller লেখা আছে
inquiry reports of Pakuria and Ghurni
আসেনি
held on 25th September 2020 and 28th of September 2020 respectively. Stop. For other information, it will be open for the petitioner to apply before the competent authority. It will be open for the petitioner to apply, pinpointing the documents and the information sought for. Disposed.
Grateful Lordship.
In appropriate case, my lord,
It
I
may be
contemplate
required
to challenge this this provision.
Yes.
Grateful Lordship.
Yes, my lord, I'm here for the petitioner. This is for quashing of a case which is running before the Juvenile Justice Board, Bidharnagar.
Who is your other side? Did you
Other
serve
side has been
notice?
served.
When did you
first-
serve?
Yeah, yes.
When did you serve?
24th June 2024.
Right. Thereafter, you mentioned the matter for upgradation.
My lord.
Did you give notice?
Yes.
Where is the notice? Please show.
Right now, can I notice the
You are required to show. Otherwise, how will the other side get to know?
notice? No, এখানে না ওই mention in notice আছে. I think my clerk has misplaced. Should I come back, notify them and come back, my lord?
Please come. None appears on behalf of the respondents. Stop. Let a notice be served upon the respondents, intimating that the matter will appear in the list on 26th of February. Affidavit of service filed in court is taken on record. Inquire from the GP office who is the learned advocate who has been engaged. Serve notice upon him or her.
My lord.
And there is a private respondent. Serve.
My lord.
My petition.
Yes.
Lord, the petitioner, my lord, before your lordship, my lord, is, my lord, a society whose members, my lord, are academics and, my lord, doctors and people who are, my lord, associated, my lord, with medical.
Independent Research Ethics Society.
Yes. Ethics. Yes.
I'm for the private respondent.
Yes. Now, my lord, the product in question here, my lord, is, my lord, a product which is being sold by the private respondent, my lord, that's respondent number 7, under the brand name Doctor's Choice. My lord, it's mustard oil. My lord, described as, my lord, Kachi Ghani mustard oil. My lord, under the brand name Doctor's Choice. Now, my lord, we had, my lord, a grievance, my lord, against this. my lord, saying, my lord, that under the Food Safety and Standards Act, my lord, a product could not be sold, my lord, under such a label or brand. Because, my lord, the doctor's choice, my lord, as my lord appearing, my lord, in my lord, the label, my lord, would suggest, my lord, that this is recommended by the doctors, and my lord, it has, my lord, the my lord, choice, my lord, doctors, the
The
O, my-
sanction of the doctors.
correct. The impression is, my lord, that doctors have approved this. Then there is a heart, my lord, where the O is that it's good for the heart, and it has a stethoscope. So, my lord, we made representations, my lord, to the authorities, my lord, which was one set of representations. I'll come to the label later, my lord. My lord, from February 2023 to October 2023, they are, my lord, all on record. My lord, no steps were being taken. Then we, my lord, issued, my lord, a, my lord, communication, my lord, in November, 29 November 2023. My lord, again, my lord, no steps were being taken. So, my lord, we filed a writ petition, my lord, saying, my lord, that the state authorities are, my lord, not taking any steps, and my lord, sought, my lord, certain, my lord, directions. My lord, kindly come to, my lord, the prayers, my lord, in that writ petition. Lordship will find that at page 202, my lord, volume 4. I think everything's together, my lord. Volume 4, page 202.
Yes.
My lord, prayer A, my lord, your lordship will find a writ of and the nature of mandamus directing the respondents, and particularly respond number 3, to take cognizance of the complaint dated November 29, 2023, and to act in accordance with the provisions of the Food Safety and Standards Act. This was, my lord, our prayer. Now, my lord, while the writ petition was pending, my lord, during the course of the writ petition, my lord, my lord, document was handed over, a report, my lord, describing itself, my lord, as a report, my lord, in the form of an affidavit on behalf of respond numbers 4, 5, and 6, my lord, who are part of the Food, my lord, Safety and Standards Authority of India, my lord, authorities. My lord, this report, my lord, was handed over on 7th of May, 2024. It will be evident from the order, my lord, your lordship will kindly see the order, my lord, in this. At page 228, my lord, kindly have a look at the order, my lord. A report is filed in court today by the respondents be kept on record. However, unfortunately, no copies of the same have been circulated previously. A copy is given here and now to learned counsel for the petition as well as the state. Party shall come prepared on the report on 9th May when the matter shall be placed. Now, my lord, this writ petition, then, my lord, our grievance was no steps were being taken. So on 9th of May 2024, page 229, my lord, it's there earlier also.
Yes.
Now, my lord, your lordship will find, my lord, at page 39, my lord, either 229 or page 39, my lord, or whichever one your lordships take. My lord, the order, my lord, of 9th of May, my lord, I'll just place. Learned senior counsel appearing for the petitioner fairly points out that as per the report filed on behalf of 4, 5, and 6, the decision has been taken on the complaint made by the petitioner. Now, my lord, upon hearing learned counsel and perusal of the report, it is evident that the respondent authorities have taken a decision on the complaint of the petitioner on October 12, 2023, annexed at page 13 of the report filed by the respondents. So, my lord, kindly note the date. It's 12th October. Our last representation was 29 November. Now, my lord, accordingly, cause of action regarding inaction on the part of the authorities has been rendered infructuous. However, needless to say, it will be open to the appearing parties, including the petitioner, to challenge the decision now taken by the respondent authorities in an independent writ petition challenge. Accordingly, so-and-so is disposed of by keeping on record the report filed by 4 to 6 and granting liberty to the petitioner and any other aggrieved party to challenge the decision taken by the respondent authorities on October 12, 2023, annexed at page 13 of the said report. Since the said decision was disclosed to the petitioner only by way of report for the first time, appropriate forum court taking up the challenge shall duly consider such fact while considering the question of delay, if any. It is made clear that the contentions of the parties regarding such proposed challenge have not been gone into on merits by this court and the appropriate open to the appropriate forum court to decide all the issues. There will be an order. Now, my lord, we are now challenging, my lord, that report and the decisions which have been taken, which are enumerated. Now, my lord, kindly come straight away, my lord, to my lord, the my lord report, my lord, which is my lord at page, my lord, page 206, my lord, which I had drawn your lordship's attention to, and my lord, straight away, kindly come to paragraph 6 at page 208.
Yes.
My lord, it is submitted that the representations were received from the petitioner alleging misleading brand name and misleading claims on the product label. That pursuant to the said representations, 3 improvement notices under section 32 of the FSS Act were issued to the food business operator, that's respond number 7, by the concerned licensing authorities on the following dates. So this is the action taken 15th March, 18th April, 12th of October. Again, my lord, before my lord, my representation of 29, I'll my lord place these. Then it is submitted that with respect to the misleading brand name, that is Doctor's Choice, the Directorate of the Enforcement and Regulatory Operations, ERO, vide letter dated 12th October, informed about FBO submissions that it is not a claim but a trademark, and taking action with respect to the trademark is out of the purview of the respondent, FSSAI. A copy of the letter dated 12th October is so and so. It is further submitted that in compliance with the improvement notices, FBO has already rectified, that's the food biz private party, the product labels as directed and also submitted copies of the recti. Additionally, FBO also provided a disclaimer regarding the trademark. It is also pertinent to submit that subsequent to compliance, FSSAI received a communication from Central Consumer Protection seeking updated information in the matter. It is submitted that in response to CCPS inquiry, respondent furnished a reply comprehensively addressing the concerns and provided relevant details, copied. Therefore, submitted in view of the above submission and matter, present writ petition, so and so. Now, my lord, kindly have a look one by one, my lord, at my lord, these documents. 15th March, improvement.
So this is the impugned order that you are challenging
Correct,
now.
my lord, that is one. Second is, my lord, the directions, my lord, which have been given by this, and my lord, the action, my lord, on the part of the respondents to say, look, it's a registered trademark, we can't do anything about it, is completely contrary to the statute. I want to, my lord, show that.
But then can this be decided without affidavits?
My lord, affidavits may be filed, but my lord, while this was, my lord, pending,
yes,
my lord, my request would be, my lord, short affidavits, my lord, short direction, subject to your lord ladyship's approval. Come on, use your.
Lord, I'll file short affidavit. I have not filed any affidavit, nor has any direction been given for filing of affidavit.
It's coming up for.
It's coming for the first time.
Yeah.
And secondly, my lord, there is an alternative statutory remedy which they should avail of. If they are aggrieved by the improvement notice and the decision taken, there is an authority which is set up under the statute to whom they can approach.
My lord, it's a without jurisdiction, my lord, action which has been taken. And my lord, kindly have a look at this, which has come, my lord, while this was pending. My lord, I'm giving a copy here. My lord, on 18 November 2024, my lord, this authority, my lord, writes to, my lord, to us, my lord, pointing out, my lord, what has, my lord, happened. And, my lord, kindly see, my lord, the letter of, my lord, 11th of November 2024, my lord, because we had, my lord, another representation, my lord, which had, my lord, been issued in May, 29th of May 2024, which is at page 232. In response to that, my lord, kindly have a look. This letter is in reference to the critical issue regarding use of misleading trademarks by certain food business operators, which poses a significant threat to consumer safety and health. Recently, a trend has emerged where food business operators utilize trademarks that may deceive consumers about the actual nature and health benefits of their product. Some of the significant examples are Doctor's Choice, the same product. This branding suggests an endorsement by healthcare professionals, potentially leading consumers to believe the product is a medically validated option, which is misleading without proper evidence. And, my lord, here it's admitted fact, even by them, my lord, that, my lord, when they, my lord, produce the revised label, my lord, which is page 219, kindly have a look, my lord. I hope, my lord, it's colored, my lord, in your, or at least, my lord,
It's not a colored one,
Oh.
but then.
my lord, doctors, your lordship seen, my lord, kindly have a look. Doctor's choice.
Yes.
Now, my lord, heart shape O, and my lord, stethoscope. And
On the next page.
on the next page, my lord, left-hand side, my lord, your lordship will get the
Yes.
stethoscope. And my lord, kindly see the disclaimer which they give to try and, for my lord, kindly see the disclaimer is, my lord, the next page, right-hand bottom disclaimer, doctor's choice is only a brand name or trademark. It does not represent its true nature. My lord, makes no difference. This kind of a disclaimer, because, my lord, the label regulations say, my lord, any brand name, my lord, any trademark, which, my lord, violates, my lord, the provisions of the regulations, my lord, cannot, my lord, be, my lord, it's a complete prohibition. And the Act says it has overriding effect over all laws. Now, my lord, the Trademark Act, latest is of 1999. The Food Security and Safety Act, my lord, if I'm not mistaken, is of 2006. And, my lord, the regulations under those acts, my lord, are of 2018 and 2020. So, my lord, we have a situation here where, my lord, the FS and SAI, my lord, FSSAI of, my lord, is recognizing this, my lord, to be, my lord, a, my lord, trademark, my lord, which is misleading, because it's not the nature of the product. There's no evidence, my lord, adduced that doctors have, my lord, endorsed, my lord, this product, that is good for the heart. My lord, this is not only an unfair trade practice, my lord, it is misleading.
No, this letter is given to you on the 11th of November.
Yes, my lord, while, yes, ma'am.
But then this is only an information. Did the FS?
No, nothing else. No, they should have stopped. That's exactly what I'm saying. My lord, that they, after having come to this finding, there was no need to refer to, my lord, the patent office or, my lord, the trademark office. The Act itself says that they can take steps, my lord, to stop, my lord, the production and sale.
All right.
It's a prohibited, my lord, item, my lord. They can't make this claim.
My lord, if my learned friend has finished, my lord, may I refer your lordship to a section of the Act?
But then we'll decide it only after filing
After
affidavits.
affidavit, yes.
But I want to hear the food safety and standards. Yes. Any further steps taken after 11th November 2024?
They'll have to take the instructions regarding this, my lord. If your lordship kindly allow me, lordship, I will file the affidavit, my lord. If your lordship
That you will file, but this is the communication that has been placed in court today. Any further steps taken or not?
Instructions, lordship, in this case.
Does the state have any role to play?
My lord, they appoint, my lord, under the Act, my lord.
The food commissioner is there.
Yes.
Complaints to us also, my lord.
Yes.
We have informed them on both the occasions that this is a central license which has been issued to this Boj refinery, which is the actual name of this doctor.
Central license means?
The central license, my lord, the license granted by the central authority.
Central authorities.
Notification which I have brought, my lord, for abundant caution, my lord, which says that if you lordship kindly take these three. This first one.
Copy আছে, Susanno.
It's 12 May 2023, issued by the FSSI. It says kindly take note paragraph 1 in the first page, second last paragraph. That all the regular inspections, including for the complaints, any other reference, including complaints received directly from the State Food Authority against centrally licensed food business operators (FBOs) shall be carried out by the Central Food Safety Officers. This is one part. Then kindly turns over to the next one. There is a earlier one, 6 July 2021. You will find that 2 Roman I is already marked that all inspections of the food business operators having central licenses shall be carried out by the Central Food Safety Officers. The State Food Safety Officers shall, on request, provide all feasible assistance to the Central Food Safety Officers concerned in this regard. And kindly turns over to the next one also. That is 2nd December 2021. Your lordship will find Annexure D. The paragraph number 3 in this regard is further clarified that in case of complaints or grievances or references, etc., received by the state food authorities against the FBOs, having central licenses operating in the respective state or union territory, the same shall be forwarded to the concerned regional director of FSSAI. Such complaint shall be examined and scrutinized by concerned regional director, and further action shall be taken by him or her under the intimation to the concerned commissioner of police. Therefore, my lord, we have intimated. If your lordship, my lord, travels to the last page in that bunch, that is 14 June 2024. But we have informed the regional director. But I'm sorry, Manoj. Yes, the represent to the president of Independent Ethics Research Society. This fact, what I've just treated with your lordship, Manoj. This thing we have informed them that they are having a central license. Therefore, actions, if any, will be taken by the central food safety officers.
But you did not communicate to the central food.
Just the page before.
This is from the
This is from our
additional
Health
to
and
the
Family Welfare Department
to the regional director
of FSAI.
Very well, please come. The petitioner alleges that the respondent number 7 is selling a food product under misleading brand name. Stop paragraph. The petitioner refers to a communication dated 11th November 2024 addressed to the petitioner by the director of the Regulatory Compliance Division, Food Safety and Standards Authority of India, mentioning that the use of the name within quotes doctor's choice is a misleading trademark
And label, my lord, trademark and label.
Where is this label mentioned?
My lord,
It
it's
is
the
a
label, my lord. It's a
misleading trademark which poses significant threat to consumer safety and health. Utilize the trademarks. Let us see restricted to this.
very well. My lord, there are, my lord, the regulations I've quoted relate to label as well as, my lord, trademark.
All
That's
right.
fine.
You will,
Use of the name doctor's choice is a misleading statement
by the food business operator, which poses a significant threat to consumer safety and health. Stop paragraph. Prayer has been made to immediately stop the private respondent from selling the said product with the said trade name and label. Paragraph. Learned counsel representing the private respondent submits that the writ petition will not be maintainable here as the petitioner already has an alternative remedy. Stop paragraph. Prayer has been made to permit the private respondent to file affidavit in the matter. Stop. Learned advocate representing the Food Safety and Standards
Authority
of India seeks time to file affidavit. Stop paragraph. Learned advocate representing the state respondents relies upon the notification. Is this a notification or these communications?
So communication, my lord, by the regulatory authority to
by the communications made by the state regulatory authority intimating the petitioner that the license in favor of the private respondent is issued by the central government, and accordingly it is the central authority that is to take steps in the matter. Paragraph. Upon hearing the parties, it appears that the writ petition is to be decided upon exchange of affidavits. Step. Let affidavit in opposition by the respondents be filed
within 2 weeks, my lord, I think.
within 3 weeks.
Within 3 weeks, my lord.
Reply if
I didn't want to be on this side because it may.
reply if
State
any-
is there also.
within-
Management can file it in 1 day, my lord. but
Yes,
my lord,
that
the
I
state-
understand, but the
the state,
central
no, my
authority
lord,
is
that's
there.
why.
State doesn't have much role, but the central authority is there.
Central authority, my lord, because the instructions have to be taken. My lord. I don't take instructions, I just draft.
Reply if any within a fortnight thereafter. Stop. Liberty to mention the matter for hearing upon
Obliged.
completion of affidavits. Stop. Pendency of the writ petition will, however, not stand in the way of the Food Safety and Standards Authority of India to take measures to stop any food product that is being sold under
Doctor's choice.
the misleading trademark
My lordship,
of
kindly,
the
my lord, not
food
mention his misleading
business
because I
operator. I have not mentioned any name.
Doctor's choice, I'm selling under Doctor's choice. So
I
that
have
means
not mentioned doctor's choice over here. I have
Any.
just mentioned any. So it covers doctor's choice and whoever it is. Yes, yes. Right.
My lord, the point of maintainability is kept open, my lord, because
Yes, the point of maintainability as raised by the private respondent is kept open to be decided at the time of final hearing.
Yes.
Step. The instruction forwarded by the who forwarded it to you by the state respondents to the learned counsel be retained with the records. Acha.
Doctor's choice.
This you can include in your
Yes, my lord, or it can
reply.
be kept in, I'll include, my lord. but this-
I am
yes.
keeping it,
Very
but
well.
then you
I'll
include it in your reply.
I will.
So lordship has
My
not
lord, may I
included
file
the
the
term
affidavit
doctor's
of
choice.
service.
I have not mentioned anything. At the top only, he has a complaint against doctor's choice. That is all.
No, but I'm
Otherwise, no.
selling food products under the name Doctor's Choice, for which I've been. Then they will say the order relates to Doctor's Choice, and you're selling your food product under the name Doctor's Choice.
Listen, it is for them
Yes,
to take a
for them to
decision.
decide.
It is their communication. If they want to take further steps, they will take. And if it is without complying the principles of natural justice, doors open to you.
Yes. My lord, I'm just saying, my lord, they are dissatisfied with something from that. There is a statutory authority to hear the appeal, and they want the writ court to hear the appeal. That's what I'm saying. That cannot be done. Your lordship normally does not permit that.
I don't.
Commissioner of Food Safety.
Acha, Commissioner of Food Safety. Stated instruction is from the Commissioner of Food Safety. Respondent number 2.
And my lord, the affidavit of service I filed.
Yes,
my
yes,
lord.
affidavit of
Obliged.
service is taken on record.
Obliged, your lordship.
Yes, Passover matter. Passover matter.
আচ্ছা, আমি just মানে kindly see
আমি ওটা আর কি করবো এখন থেকে বলে কথা তোকে close করে দিয়েছি আর তুমি দিয়ে বলছো
মানে kindly see
এটা তোমার মোটে জানে কিছুই বলছে না তোমাকে
মানে item entry number 14, entry number 14, there is a transaction of amounting 10 lakhs written Gujarat. Malo, kindly see, that is third page. This is the amount due to objection. Malo, this amount has come from Axis Bank Manton branch from Biala for beautician course year long. So how this is related with Gujarat, I fail to understand, my lord. Amount that is item 14, 10 lakhs. And this amount comes to us from Axis Bank Manton branch, not from Gujarat.
Where are you getting this Axis Bank? I can see Manton branch.
That is first, second, third column. AX SK 242290019445. This is the Axis Bank in Manton, not from Gujarat. Let them produce any document.
The bank will not be able to produce anything.
Kindly see that this is not from Gujarat, my lord. That amount is disputed.
Listen,
Yes,
the bank cannot say anything about it. This is
The first page, the top portion, the top portion, the name, designation, mobile, email.
yes, cybercrime police station, police inspector's name, the
Phone
mobile
number,
number,
mail ID.
email.
This is by
everything given.
uploaded by them.
Right.
And we only have an acknowledgement copy, nothing more.
Let-
And this
then, my lord,
freezing of app account,
let me give liberty to approach
Absolutely.
copy to them.
Not serve. You go and approach these authorities.
may I say, subject to correction on what instruction I have received is the appropriate procedure of law, which this is followed in these cases, is the jurisdictional magistrate of the cybercrime police station in Vadodara is the appropriate court before whom the petitioner probably has to approach for defreezing the account upon production of the appropriate documents. The jurisdictional magistrate, upon being satisfied with the application, the necessary orders
May I
will be passed.
suggest one thing, my lord? Everything in Behala, account, duty parlor, everything in Behala, amount is in Behala branch. So I have to approach, let them be party in this writ petition.
The petitioner is aggrieved. As her bank account with the Bank of Baroda,
James Longshoreman.
James Longshoreman has been frozen. Stop. The petitioner submits that no reason has been made known to her for freezing the bank account. Stop. Prayer has been made to direct the bank to defreeze the said account. Stop. Paragraph. Learned advocate representing the bank produces instruction wherefrom it appears that the bank account of the petitioner stood frozen in response to a complaint lodged by the complainant before the PI Cybercrime Police Station at Gujarat, Vadodara City Cybercrime PS. Na comma hobe na. Gujarat, Vadodara City Cybercrime PS. ঠিক আছে? The bank account of the petitioner has been found to be involved in fraudulent transaction of fraudulent transaction. Stop. The investment is alleged to be made arising out of share market scam. Stop. Paragraph. It has been submitted that the bank did not freeze the bank account of the petitioner voluntarily. Stop. It is the police who has actually frozen the bank account to prevent any further fraudulent transaction. Stop. From the instruction placed before the court today, with a copy handed over to the learned advocate representing the petitioner, it appears that the name of the police station, the designation of the police officer, the mobile number and the email number, everything is mentioned therein. Stop. Paragraph. As the bank has submitted that the bank was nowhere responsible for freezing the bank account. Accordingly, there is no point in directing the bank to defreeze the same. Stop. It will be open for the petitioner to approach the jurisdictional court for obtaining necessary order for defreezing the bank account where the crime has been registered. Writ petition stands disposed of.
My lord, affidavit service.
Services.
My lord, may I submit it one thing, my lord? My lord, monthly list item number 60. It was dismissed for default. My lord, kindly pardon.
Monthly list item number
60.
60 has been dismissed.
Yes.
Who are you for?
I am for the petitioner.
Why were you not there?
I am engaged in court room number 28.
You should have kept somebody over here,
My lord,
told any of
this is
your
my
friends.
fault, my humble request. kindly
Item
pardon.
60, was anybody there for the respondent? It has to be checked up. এটাকে restore করে দিন।